Mr. Clerk, please record.
There is a quorum present, Madam President.
Thank you, Mr. Clerk. Do you have any items for the record?
I do, Madam President. Communication from the governor regarding appointments to the Public Roads Classification Standards Board. I have a report from the Reference Committee concerning various gubernatorial appointments, as well as a report from the Reference Committee regarding membership in the Nebraska Economic Forecasting Advisory Board. That's all I have at this time.
Thank you, Mr. Clerk. Speaker Arch for an announcement.
Thank you, Madam President. At the request of the introducer, we'll be passing over LB 137 and move to the next item on the agenda. Thank you.
Thank you, Mr. President. Colleague Senator Decay would like to announce 47 students and 3 teachers from Harrington, Newcastle, 5th and 6th grade band. Please stand and be recognized by your Nebraska Legislature. Hardington. Mr. Clerk, next item.
Madam President, next bill is Legislative Bill 1313. I have no amendments. Oh, excuse me, I do have an amendment. Madam President, Senator Dover would move to amend with 3077.
Senator Dover, you're recognized to open on LB 1313 and your amendment 3077.
All right, thank you. I'd like to speak to AM 3077. I talked to the AG this morning. There was some concern expressed about a part of my bill that has it says it has been in existence for at least 50 continuous years prior to the issuance of health benefits to members of the organization. I talked with the AG's office. They thought it might be a good idea. They don't, of course, you can decide if it would be constitutional or not until it went to Supreme Court. But in talking to the AG, he suggested I strike that. So my amendment to my LB 1313 Amendment 3077 strikes the statement that says at least 15 continuous years prior to the insurance of health benefits to members of the organization. I'd be glad to answer any questions anyone might have. Thank you.
Thank you, Senator Dover. Senator Erdman, you're recognized.
Thank you, Madam President. I wonder if Senator Dover will yield to a question.
Senator Dover, will you yield?
Yes.
Senator Dover, what exactly does your bill do for Farm Bureau?
Well, I would say what it does is, get my glasses on here. It wouldn't be just Farm Bureau, Senator Erdman, it would also be Farmers Union. So if you have, just to generalize, an ag-centric organization, the ACA has a number of ways that they have carve-outs. And one of the carve-outs is religious, and therefore we have MediShare, and there's other Christian sharing organizations that provide healthcare benefits. And what my bill does, it allows ag-centric membership organizations, farmers unions, Farm Bureau, I'm sure there probably are some other ones, to offer an affordable alternative. And so basically I've got two of my kids are on the farm, 2 of my 4 kids, and they have a hard time finding insurance. And I really believe the benefit of this bill is a provider network. It's different. I was on MediShare as affordable, and actually my Farm Bureau insurance agent, I said, what do you do about affordable? I'm paying $35,000 a year with my 4 kids with deductibles. And he said, actually, I have MediShare. And so I went on MediShare. The problem with MediShare is they tell you to go to this website, they list the people that are providers, and then when you call a provider up, you have to call them and say, no, we don't honor MediShare. You call another one, they do. So the problem was finding who actually carries it, who didn't. The benefit of this is you have United Health would be the healthcare network provider. They're in 5 other states currently, and they have it would be a structured provider network across the state of Nebraska. So it's not just Farm Bureau, Farmer Union, or any ag-centric membership group. Okay. And I think the problem is perhaps that the 50 may limit it too much, so my amendment strikes that. And that was some concern that was expressed to the AG's office. So he suggested that. That's why I did that.
So you're striking the clause about up to 50 years.
Yes, I am.
Okay. So then you're going to put together a group of people to go to an insurance company and bid for the opportunity for them to insure this group, or how does that work?
Could you restate your question, please?
Well, okay. So you're going to form this group, whatever it is, whatever ag group it is, and then they're going to go and contract with an insurance company to provide insurance for them. Is that the program?
No, actually, I don't know if I follow your question, but let me attempt at answering it. So they would contract with a third party that would be able to fully handle the administration of an insurance of this health insurance group. And so they would be able to handle admissions, calls, requests, if someone called in because where do I go and those kind of things. So there would be a third party group that does that. And then they would then contract with The second part of the group health insurance, which is the network provider, which I believe would be United Health, is my understanding. In one of the cases, I have no idea what the others might do.
Okay. All right. So I noticed in the committee statement that the only people who testified were Farm Bureau people. That's why I assumed this was a Farm Bureau program. Was there other people that were in favor of this that I didn't see? Maybe written testimony that came in?
I would have to.
1 minute.
Oh, just 1 second. I believe so. I had, on behalf of the Ag Leaders Work Group, we support LB 1330. That represents the Nebraska Cattlemen, Nebraska Corn Growers Association, Nebraska Farm Bureau, Nebraska Pork Producers Association, Nebraska Sorghum Producers Association, Nebraska Soybean Association, Nebraska State Dairy Association, Nebraska Wheat Growers Association, and Renewable Fuels Nebraska are supportive of my bill LB 1330. So I would say that probably, I'm told that group represents 96% of the ag receipts in the state of Nebraska.
Okay. All right. I have other questions. My time's about up. I'll get on the mic again and ask you some more. Thank you.
Thank you.
Thank you, Senator Erdman and Dover. Senator Jacobson, you're recognized.
Thank you, Mr. President. Well, let me jump in here a little bit on this bill. Senator Reapy and I had worked with Senator Dover out of the gate to bring this bill, and he agreed to prioritize the bill and brought the bill. Senator Reapy and I both had met with Farm Bureau, who brought the idea and who has worked in other states. There's several other states who have adopted this particular program. It really started in Tennessee, and I think the best way to characterize this is like a VIVA plan that another employer plans that are out there today, although most all those plans are part of the ACA. But I will tell you that as it relates to this particular plan, Farm Bureau is the one who brought it on behalf of their members, but it is not limited to Farm Bureau. But yes, they're the ones who brought the bill. As Senator Dover has outlined, all of the ag groups are behind supporting this bill because what they're looking for is a lower cost program, particularly for ag producers across the state, as opposed to the ACA plans that are out there today, because there's very limited options and they're very expensive. Now, this plan is, because it's not a qualified plan, there can be discrimination within the plan, meaning that they can have a higher selection rate in terms of who qualifies for the plan. So they're going to be taking the less sick people, if you will, healthier people, and passing on that lower rate. Not any different than an auto insurance company that goes out and says, if you're a great driver, you got a great clean record, we're going to give you a lower premium. That's what this program would do. And just like in a VIVA plan, there would be United Health is the national insurer that works with this program in Tennessee and the other states that are doing it to provide the overall management in terms of approving claims and so on, and also helping with the underwriting. But the plan sponsor, in this case would be Farm Bureau, or it could be Farmers Union or any other farm organization that believes that they want to do this, but it would take a pretty good breadth of membership to make this work. So I think it's a great alternative for ag producers, particularly younger ag producers that are out there in the state of Nebraska looking for health care coverage. This is a direction that they can go. I think it's a great program, and I'd encourage your green vote to move it forward. Thank you, Mr. President.
Thank you, Senator Jacobson. Senator Erdman, you're recognized.
Thank you, Madam President. I appreciate that. So as I was looking at the bill here a moment ago, this organization that qualifies for this would have to have membership in every county. I believe that to be the case. I wonder if Senator Dover would yield to a question about that.
Senator Dover, will you yield?
Yes.
Senator Dover, thank you. So did I read that correctly? It said that this organization has to have a membership in every county in the state to qualify for this?
And you're referencing what line?
I don't know. I had it on my computer and my computer shut off. But I did notice that it said that the agency the organization had to have membership that paid dues and then were in every county.
Yeah. So so a statewide organization.
Okay. So those people that you recommend, that you read off that were in support, like corn growers, cattlemen, and those, if they didn't have membership in every county, then they would not be eligible to do this?
I don't think that I had said that these people were going to start getting into the insurance business. I think you had asked.
No, I didn't say that. My question is, those organizations would not be eligible to do this because they don't have a membership, if they didn't have a membership in every county. Would that be right?
Correct.
Okay. So there is a constitutional provision. It's Section 318, and it says the following: granting any corporation, association, or an individual any special or exclusive privileges, immunity, or franchises whatsoever. Is this in any way violation of that constitutional amendment by doing this?
In my conversation with the AG office, the only concern that he had was the 50-year, which I then am amending here in 1377. So my understanding in discussions with the AG office is that we have addressed any concerns on constitutionality that he has.
Okay. All right. Thank you.
Thank you.
Thank you, Senators Dover and Erdman. Senator Jacobson, you're recognized.
Thank you, Madam President. Let me also respond to the last questions here that Senator Erdman raised. So first of all, let's be clear on special legislation. Okay, we can pass legislation that says you can only do this in a city of the primary class. And there's only one in the state of Nebraska today, and that's Lincoln. And that, or we'll say something on only the metropolitan class, and there's only one city in Nebraska in the metropolitan class, and that would be Omaha. Now, why is that not special legislation? Because Grand Island could grow into a city of the primary class, and Lincoln could grow into a city of the metropolitan class, so we're not limiting it, okay? And that's really what's happening here, is we're not saying that this is for Farm Bureau. We're saying that this is for an ag organization that has membership in all counties. So Farmers Union, corn growers, anybody else could do the same thing. Now, I would tell you that you're going to need some capacity to be able to pull this off. Farm Bureau is the largest farm organization in the state of Nebraska. They have membership across every county. They also provide insurance products today. So they're the natural one to do this, and they're the ones who brought the bill. But certainly any other organization could grow into what Farm Bureau is today. So that's why the Attorney General has given his opinion to privately, I guess off the cuff, to Senator Dover, that if you eliminate the 50 years, that you've made this to where it's not special legislation. Nobody's concerned about targeting and trying to hold anybody else out, but I will tell you that it will take someone, you're gonna need volume to make this work. And so you don't want to have a lot of players trying to meddle in this business, or you're not going to provide the savings that we need to provide. So I think what we're really after is, how do we provide an alternative insurance product for farmers and ranchers across the state that's more affordable for those who can find a way to qualify, and that's going to be a key, for a lower premium. Now, I would tell you that a lot of the older farmers are probably going to have to look at Medicare, Medicaid, Medicare supplements, Medicare Advantage, or an ACA insurance program. But this is another alternative to make it work for younger farmers and ranchers. And I think the bill passes constitutional muster, particularly with the amendment. And so again, I would encourage you to vote in favor of AM 3077 and the underlying bill LB 1313. Thank you, Madam.
Thank you, Senator Jacobson. Senator Reapy, you're recognized.
Thank you, Madam President. I was a co-sponsor on this particular bill, LB 1313, and support it. I think it's part of the answer in terms of our rural healthcare delivery, because we do have to increase competition, and hopefully with that we'll be able to manage some cost. In the hearing, we heard from the Kansas City program. It was the Farm Bureau program there, and they currently have 16,000 enrollees, and it's been a very proven successful business model. It also, the administration arrangement, I believe, short of signing the contract, has been made that it would be administered by Tennessee, which has been in the business for many years and manages, I believe, the Kansas program and a number of others. So we're not going to incur a lot of added cost because of that. I do have a question for Senator Dover, if he would take it.
Senator Dover, will you yield?
Yes, I will.
Senator, can you answer to me? I understand that membership can be purchased for $50 at this time, but is that, or is that not limited to agricultural producers, or can the urban centers, Lincoln, Omaha, Kearney, and those take advantage of it as well?
Yes, in fact, obviously, if I speak specifically to Farm Bureau, as you stated, it was somewhere on, $50 for membership. There's probably people here that are from Lincoln, Omaha, that probably have a Farm Bureau insurance policy. It's just that would be the same. So, yes, anyone, it's not only, I would say, not only are farming families going to benefit, but I'll say many families will benefit, whether I'm from a real estate background also. And realtors, because they're independent contractors, continually struggle in our association to trying to find affordable health care plans. And this would really help out there. And I know that Senator Von Gilleren said that for those people trying to start up their own companies would also be a fantastic solution. So yes, this would not benefit just farming families, definitely would benefit farming families, but also many other families.
Thank you very much. I would very much encourage all of you to support AM 3077 and the underlying bill of LB 1313. I think it's good for the state and good for the citizens. Thank you, Mr. President.
Thank you, Senators Dover and Reapy. Senator Dover, you're recognized.
Thank you. I'd like to, I was asked earlier by Senator Erdman as far as membership equipment across counties. I'd just like to clarify that a little bit more. So in the bill, line 16 says, you don't have to have membership in the counties. You have to provide membership opportunities for eligible persons in each county of this state. And so to be quite truthful, anyone offering insurance in the state of Nebraska would offer the opportunity to buy insurance, I believe, in any county. So it isn't as restrictive where you have to have memberships in each. You simply have to offer the insurance statewide. And I don't think we'd want to have a bill that precluded everyone in the state of Nebraska from enjoying an alternative affordable health care plan. And I would encourage everyone to support AM 3077. I yield the rest of my time to the chair. Thank you.
Thank you, Senator Dover. Senator Erdman, you're recognized, and this is your third opportunity.
Thank you, Madam President. I appreciate that. So I wonder if Senator Dover will yield to a question.
Senator Dover, will you yield?
Yes, I would.
Senator Dover, first of all, thank you for clarifying that on each county membership. I appreciate that. So what financial benefit will Farm Bureau receive from starting this organization or this group of people?
I have no idea, to be quite truthful. I'm simply focused on my understanding of this offering is that it provides affordable health care plans, much like the Christian sharing plans, but with a wider, more structured provider network. I'm also told that it will provide better coverage. I don't know about that, so I'm not going to say that. I mean, but I'm also told that it'll be very similar in price to the other Medishare and other Christian sharing group healthcare plans, but with a structured provider network, and that is a huge benefit. Having had Medishare for quite a number of years for my family, and currently my daughter, who farms by Madison, is using Medishare, and I believe truthfully that this insurance will provide another alternative, but again with a better provider network for the people that purchase it. Thank you.
Okay, so someone will have to administrate this, and that will Farm Bureau be the administrator of this group?
Yeah, so I'll give you a brief history, Senator, but thank you for that question. So back before the ACA, the Affordable Care Act, we had insurance, like I think probably looking around the room, like most of us were used to. So if you chose not to smoke cigarettes, if you chose to lead a healthy life, and those kind of things, you would go in and get a physical, and they would put you in a group. And really what this healthcare plan does, it takes us back to where if you chose a healthy lifestyle, you would benefit from that choice by receiving a reduced premium on your healthcare plan. And so that's really, and so what happened was, let me reframe myself. So what happened was then once the ACA came out, most of the other states across the United States, actually, they had some kind of modified agreement with Blue Cross Blue Shield, and they would sell their quote, their package deal that they made with Blue Cross Blue Shield. Well, what happened then when the ACA came out, all of a sudden, they couldn't do that anymore. And Tennessee was, I believe, one of the few states, was my understanding, is one of the few states that chose not to go with Blue Cross Blue Shield. They kept the required staffing to administer a healthcare plan, and so they could handle the administration. They could handle people filing for whatever simply had. So basically, what happened was Tennessee became one of the few states that actually still had the required staffing to actually administer a healthcare plan. And because of that, they were able to stay in the game. And then over the years, what's happened is now, I believe 5 states we use that strength of Tennessee to administer as a third party a plan very similar to this. And we're hoping, obviously, in the state of Nebraska, that we can offer this option to the citizens of Nebraska for another affordable healthcare plan.
Thank you so much for the explanation. I appreciate it. Thank you.
Thank you.
Thank you, Senators Dover and Erdman. Senator Clements would like to recognize 10 fourth grade students from St. John the Baptist Catholic School in Plattsmouth. Please stand and be recognized by your Nebraska Legislature. Seeing no one else in the queue, Senator Dover, you're recognized to close on your amendment. Senator Dover waives closing. The question is, shall Amendment 3077 be adopted? All those in favor, vote aye. All those opposed, vote nay. Have you all voted? Record, Mr. Clerk.
39 ayes, no nays on the adoption of the amendment.
The amendment is adopted.
I have nothing further on the bill, Madam President.
Senator Ballard, for a motion.
Madam President, I move that LB 1313 be advanced to E&R for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. LB 1313 is advanced. Mr. Clerk, for the next item.
Legislative Bill 1004. I do have E&R amendments, Senator.
Senator Ballard for a motion.
Madam President, I move the E&R amendments to LB 1004 be adopted.
Colleagues, you've heard the motion. All those in favor vote aye. Say aye. All those opposed say nay. They are adopted.
I have nothing further on the bill.
Senator Ballard for a motion.
Madam President, I move that LB 1004 be advanced to E&R for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. It is advanced. Mr. Clerk.
Legislative Bill 894. There are E&R amendments.
Senator Ballard for a motion.
Madam President, I move the E&R amendments to LB 894 be adopted.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. They are adopted.
Senator Ibach would move to amend with AM 2927.
Senator Ibach, you're welcome to open on your amendment 2927.
Thank you, Madam Chair. Today, I ask for your support for AM 2927 to LB 894. AM 2927 strikes AM 2764, which was adopted on general file that allowed individuals with deferred action for childhood arrival status to receive law enforcement training and certification. As you may remember, AM 2764 was based upon LB 918, and I voted in favor of advancing that bill from Judiciary Committee. While I understand the workforce issues facing law enforcement, I was not fully on board with attaching the amendment to LB 894, but I allowed the members of this body to vote their conscience. In the days following the adoption of AM 2764, numerous members have approached me asking if we could remove that language due to some concerns that have been brought to light. For instance, AM 2764 applies to those with DACA status only. Other immigrants who are here legally, such as those with work permits or those with green card status, would still be prohibited from becoming a law enforcement officer in Nebraska. I do not believe that this is fair to allow one group of individuals without citizenship while continuing to exclude other groups. This amendment also raises questions when it comes to public retirement plans in Nebraska. I don't know what would happen if individuals with DACA status were to contribute to these plans, only to have their legal status and therefore law enforcement certification taken away by future Congress or a Supreme Court decision. Senator Wayne and I have discussed this at length since its adoption, and I would welcome discussing a more comprehensive, more vetted piece of legislation next year that addresses these concerns. But I think adding AM 2764 to LB 894 opens a conversation that should be studied further. Therefore, I ask you to support AM 2927 to keep LB 894 a clean bill. This would allow stakeholders for LB 918 additional time to address concerns that have been raised in this body and by the public over the interim. Thank you, and I would appreciate your green vote.
Thank you, Senator Ibach. Senator Kavanaugh, you're recognized. Michaela Kavanaugh.
Thank you, Madam President. As I was listening to the opening on this amendment, I looked up the vote on the previous amendment, 2764, and it seems that 36 individuals voted to adopt this amendment. So I guess I'm a little confused as to why we would be withdrawing this amendment when it was a large majority. Would Senator Ibach yield to a question?
Senator Ibach, will you yield?
Yes, I will. Thank you.
Thank you. So there were 36 votes for this, and I understand that there's other populations that could be included in this, but we have to start somewhere. DACA individuals seem like a great place to start.
Well, I think if you, which I did, I researched after a lot of comments from folks regarding on social media and in the body. If you go to U.S. Citizenship for Immigration Services, in there it outlines what DACA recipients are qualified to do. And I think because they actually receive, they're considered lawfully present. However, deferred action does not confer lawful immigration status. And so technically they are not citizens. And then if you look.
But DACA are children who grew up in America.
Yes, but they still don't have citizenship.
Right.
And they also are considered lawfully present, but not lawfully conferred. So it goes on further, it says, and this is kind of the kicker on the sheriff's bill, which is why I said, if we want to continue this conversation over the interim, I'm going to encourage it, because it says it is a federal crime for a non-citizen, which DACA recipients are a non-citizen, to possess any firearm or ammunition, and this prohibition applies to DACA recipients.
Aren't there other states that are currently doing this?
I do not know that. I don't believe anywhere. The other issue is if a Supreme Court,
California and Colorado, I guess, are doing this.
I don't know that, I'm sorry.
That's what I'm being told by others.
But the other issue is if the Supreme Court would not give DACA recipients their access to being local, then they would be removed from their qualifications anyway.
Sure, but they would have to do that. And it doesn't seem, if this is happening in other states and they aren't pursuing it in other states, that we're not in much jeopardy of it happening.
Well, I don't know about that jeopardy, but
And there seems to be very broad support in the body for this.
I think there was broad support before these factors were brought to light.
Those factors have always been in existence. Those are the reality of the DACA individuals. That's not new information at all.
Well, I think when you look at the fact that DACA recipients cannot carry a firearm or ammunition, that would prohibit them from carrying out the sheriff's duties as assigned. Would you not agree with that?
But doesn't this Senator Wayne's amendment address that?
No, it just makes them qualified. And we might want to ask Senator Wayne the details on that.
Okay, well, thank you for answering my questions.
Thank you.
I'm going to vote against AM 2927 since I already voted for this,
1 minute.
as did 35 other of our colleagues. Thank you, Madam President.
Thank you, Senator Michaela Kavanaugh and Iba. Senator Jacobson, you're recognized.
Thank you, Madam President. Well, let me just remind everyone that we often hear about the legislature's second house, okay? And we also have 3 rounds of readings so that when we do something on general file, the second house has an opportunity to weigh in. I can show you the emails that I've gotten from my constituents and the phone calls. The second house has made it abundantly clear to me that they don't like this amendment. And so I will be voting to remove the amendment, even though I voted for it initially. And I also want to make clear why I voted for it initially. I will be the first one to admit that I did not understand all of the ramifications of having DACA status. DACA status has been around for a long time, since President Obama. These are kids who came here illegally with their parents. They weren't born here. If they were born here, they would be citizens. They weren't born here. Their parents came here illegally, and they're here as a result of that. President Obama issued an executive order staying them from being deported. They have to renew that every 2 years. As Senator Iba pointed out, they're also, because they're not legal citizens, they don't have the authority to carry a gun. One of my constituents is a former Border Patrol agent who made it clear to me and laid out for me what those rules are and why he was opposed to it. And that's why I now will be voting for the amendment, for the original bill, as long as the amendment's gone. Otherwise, I'm going to vote no on the bill. I think the underlying bill is a good bill, but I think we have to recognize the fact that DACA, people that are here under DACA status should not, are unable to carry a firearm, and then therefore should not be in law enforcement. Let me also say, however, that we have a packing plant being built in North Platte, and I'll guarantee you that we're going to be relying upon people with green cards. And we do have a workforce issue in this state. And that's why I leaned towards approving this originally, because I wasn't aware of the firearm prohibition and I wasn't aware of how DACA worked, but I am aware of how green cards work. We have physicians working in our hospital system and nurses that have green cards. And they, like DACA status individuals, pay taxes and so on. So my issue has to do simply with their legal status and the restrictions that go with their legal status. But I want to also be abundantly clear that without legal immigration, including green cards, We do not have an adequate workforce in this country. We don't have an adequate workforce in this country with those status. So I'm supportive of green cards and anyone who's here on a legal status that's permanent or can be permanent. Okay, but DACA is not a path to citizenship. And if there's a new president in the White House, that status could go away with one more executive order and they would all be subject to deportation. So we don't want to forget that piece of it. So that's why I'm voting for AM 2927 and will vote for LB 894 only if AM 2927 goes away. So with that, thank you, Madam President.
Thank you, Senator Jacobson. Senator Blood, you're recognized. And waves, Senator McDonald, you're recognized.
Thank you, Madam President. Good afternoon, colleagues. Asking Senator Ibaugh a couple questions just now, and my concern is waiting till next year. How do we get there this year? I understand the idea of what the feds have put in place, but also my question had to do with the military. And how does it work with the military, where you join the military, and during that process, your DACA, you're possibly, as I've talked about before, work authorized citizen here in the country paying your taxes. You are recognized based on you have either your Social Security number or your work authorization number. So I'm trying to figure out, how do we get there now? Is there other places in the country, for example, that possibly said, okay, you can carry the firearm when you're on duty, you just cannot take it when you're off duty? If there's someone that's done that in a different state, is there a way to do this right now? As Senator Jacobson just mentioned, our birth rate in the United States right now is 1.6. It needs to be 2.1 to actually sustain our workforce. Right now, we are not on a path to have actually people that we can train for our workforce. It's getting worse every day. We've got people here that want to be part of this country, that have come here. You can talk about the DACA kids. You can talk about just people that have come here legally and they're work authorized right now paying taxes. As I talked about before, we'd be the last state to harmonize with the unemployment insurance. The rest of the country has done this, but we have employers paying in unemployment insurance. And when these people go down and try to collect, they say, no, we're sorry, there's a glitch in the system. We cannot pay you your unemployment even though your employer has paid in and you are here legally. You're documented here legally based on the idea that your work authorized number, but we cannot give you that benefit that your employer's paid for and you have earned. But right now, I'd like to figure this out now. And how can we go forward? Is there things other states have done? I think this is something we need to look at quickly. And I still support LB 894, but I also supported the idea of doing this for DACA and other authorized workers. And I'd like to try to find a solution now this session, not wait till next year. Thank you, Mr. President.
Thank you, Senator McDonald. Senator Frederickson, you're recognized.
Thank you, Madam President. Good afternoon, colleagues. I'm listening to this debate as well, and I have been doing a little bit of research in this. So first of all, I appreciate Senator Ibaugh's looking a bit further into this, and I agree with her. I think that we should certainly be ensuring that if we are going to be passing legislation, we don't want to put ourselves at risk for further complications that are unnecessary. It does appear that two states have done this. So California and Colorado have both passed laws that would permit non-citizens, so DACA folks, authorized to work in the U.S. to become police officers. And to Senator McDonald's point about the firearm piece, I was kind of trying to do some digging on that as well. And it looks like that's something that we could address on the state level. So it says in Colorado, DACA recipients previously could not legally carry firearms. Colorado's new measure, which is Colorado HB 23-1143, which was signed into law by the governor in last April, does away with that prohibition. So I don't know if Senator Wayne's initial amendment did away with that prohibition in Nebraska or not, but I guess what I'm trying to say is that it does look like there is a way to do this that is sound and within a legal framework. If this is not in fact that way, I agree with Senator Ibaugh. I think that we should put something forward that is prudent in a legal way. But I do want to underscore that it does appear that there is some way to do this, as evidenced by some of our sister states who have successfully been able to advance with this measure. So I'm going to continue to listen to the debate on this and hopefully do a little bit more digging here to see what we can find out. Thank you, Madam President.
Thank you, Senator Frederickson. Senator McKinney, you're recognized.
Thank you, Madam President. I oppose the amendment. I think I've supported this bill. And I was doing some quick research on my laptop and I saw that it hasn't just been Colorado and California. Actually, there's been legislation passed in Washington, Illinois, and Virginia on this same issue to allow DACA recipients to be law enforcement. So I believe that, if it seems like a trend is happening across the nation to allow DACA recipients to become law enforcement. In this body, when trends start to happen, we seem to hop on board of a bunch of trends that I dislike. I would, say that, especially number one reason why I think this is a good issue to support is because the demographics of rural communities are changing in Nebraska and across the nation. And what that means is the makeup of communities in rural Nebraska are not what they traditionally used to be, and they won't be in the next 10, 20, 30 years. There will be more individuals from immigrant communities that make up rural communities in the state of Nebraska. And if we don't create pathways like this, we're going to have representation that does not look like the communities that are being represented. So we have to be creative in our policies and to allow for individuals from these communities to become law enforcement, because I believe reports and data has shown that individuals that look like the communities that they represent are less likely to harm somebody, kill somebody, brutalize somebody, and those type of things. So I'm looking at it from the perspective of an African-American man who has been brutalized by law enforcement in the past, and a communities that has been over-policed by people who don't really look like my community. And I'm trying to make sure that in the next 5, 10, 15, 20 years, rural communities in Nebraska that are those demographics are going to change and are changing. And I think everybody knows that, and that's the elephant in the room and why this bill is important, that we should pass creative policy to allow for individuals of those communities to represent those communities in law enforcement. And that's why I think this bill is important, because if we don't, we'll have communities that are primarily Latino, for example, being policed by individuals who are not Latino. That can present a lot of problems, and I don't need to go on all day what those problems could be. I think we all know what those are. So that's why I think it's important. And there's other states outside of Colorado and California that are passing along legislation that are doing the same thing. Maybe we have to tweak it a little bit to make some exceptions or some amendments to this. But the reason why I supported this is I think representation matters, especially representation from communities that are not traditionally represented in law enforcement. That's why I support this bill, and that's why I oppose the amendment. Thank you.
Thank you, Senator McKinney. Senator Dover, you're recognized.
I rise in support of AM 2927. I'd like to thank Senator Eibach for bringing this amendment. I had a conversation with the Madison County Sheriff Volk this morning, and he is very concerned that this could open up counties to potential lawsuits, and was very happy to hear that there was a potential solution for the DACA issue. Also, I just think listening to the conversation that would happen when we talked about LB 894 and then the amendment 2764, I just like to say that there was a discussion made that if it comes out of your committee 8-0 or whatever, that you need to stick with your vote. But I frankly, I think if it's close, you should. But I really think that sometimes you become more educated. Sometimes you voted on something. I've seen some votes even here on the floor, and I've probably taken some of them that I wonder, was that really the right way to go on it? They're very close, whatever. But I would encourage that if you are in a committee and you realize that something maybe shouldn't be supported, that people would have the courage or to stand up and vote opposite of the way they voted in committee, because they now know something and they now perceive it or see it differently than they did previously when they voted out of committee. Having said that, I would like to encourage again a green vote on AM 297 that takes out Amendment 2764. I encourage a green vote on the adoption. If Amendment 2927 passes, I encourage a green vote on LB 894. And I'd like to say, I do deeply appreciate Senator Ibach bringing Amendment 2927. Thank you. I yield the rest of my time to the chair.
Thank you, Senator Dover. Senator Wayne, you're recognized.
All righty. Thank you, Madam President. This is the weird spot we all find ourselves in time to time. So let me explain the dynamics of a speaker priority. Speaker priority, with the letter that went out as the guideline, says that an amendment will not be added to a bill unless the introducer agrees. Well, the introducer originally agreed. Through conversations, they want to remove this. I am not getting up and fighting it. I think it's the wrong thing to do, but it is not. We have treated speaker priorities different in this body than we do a senator or a committee priority. A senator or a committee priority, because of the guidelines that were sent out by the speaker, are different. Once that bill, a committee or a senator's priority or any other bill get to the floor, it's fair game. The only requirements are germaneness. Speaker priority requires consent of the introducer. It's okay to change your mind and get out. And I told her, and I will stand by it, that if it's on here and it'll kill your bill, take it out. That's what she's doing. She's taking it out. So I'm not fighting it in that regard. Had this been a regular senator priority, that's a different conversation. But because of the guidelines that were put out, if it doesn't want the amendment on there, take it out. Again, I think it's different for a regular one. I do want to clear up the idea that somebody can't carry a gun. They can. Senator McDonald is correct. If you look at US 18 US Code Section 925, there is exceptions for immigrants or those here legally and lawfully to carry a firearm. They can carry it at work. In California, their DACA police check their guns in every night before they leave. As when they're on duty, they can carry. Same as Illinois. So yes, Senator Kavanaugh, there are other states that do this. However, I am going back and being true to this body and being true to the individuals and the guidelines. I told you I function under rules, and those rules are clearly, if the introducer is not comfortable or does not want an amendment on there, that amendment does not attach. That is the way it is. I will tell you to vote your conscience. I will tell you if you switch your vote, I understand. I will be a no, but I'm telling you the agreement that I had with Senator Ibach, that if this bill comes out, and I told her if I have to be the 25th removing it, I will be. That is my word to her, and I'm keeping my word. Thank you, Mr. President.
Thank you, Senator Wayne. Being no one else in the queue, Senator Ibach, you're welcome to close on Amendment 2927.
Thank you, Madam Chair, and thank you, Senator Wayne, for discussing our conversations over the last couple weeks. I will just ask for your support for 2927 with my pledge that during the interim, we will work on a DACA bill, because I think it's that important as well. And so with that, I would ask for your green light on AM 2927. Thank you.
The question is, shall the amendment to LB 894 be adopted? All those in favor vote aye. All those opposed vote nay. There's been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
30 yeas, 4 nays to go under call.
The House is on the under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. We're accepting call-in votes. Senator Wayne, we're lacking Senator Bozen, Sanders, Slama, and Kauth. Will you accept call-in votes? Would you allow us to proceed? Senator Ibaugh, there was a vote open. Would you accept call-in votes? Mr. Clerk, we're now accepting call-in votes.
Senator DK voting yes.
Mr. Clerk, please record.
25 ayes, 11 nays on the adoption of the amendment.
The amendment is adopted. I raise the call.
Madam President, I have nothing further on the bill.
Senator Ballard for a motion.
Madam President, I move that LB 894 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. Aye. All those opposed say nay. No. The bill is advanced. Mr. Clerk, for the next item.
Madam President, next bill, Legislative Bill 906. There are no ENR amendments.
Senator Ballard for a motion.
President, I move that LB 906 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. The bill is advanced. Mr. Clerk, next item.
Legislative Bill 607. There are ENR amendments, Senator.
Senator Ballard for a motion.
Madam President, I move that the ENR amendments to LB 607 be adopted.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. They are amended.
I have nothing further on the bill.
Senator Ballard for a motion.
Madam President, I move that LB 607 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye.
That's all I got.
All those opposed say nay. The bill is advanced. Mr. Clerk, for the next item.
Legislative Bill 839. There are no ENR amendments or other amendments.
Senator Ballard for a motion.
Madam President, I move that LB 839 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. It is advanced. Mr. Clerk, for the next item.
Legislative Bill 834. There are no ENR amendments or other amendments.
Senator Ballard for a motion.
Madam President, I move that LB 834 be advanced to ENR for engrossing.
Colleagues, you've heard the motion. All those in favor say aye. All those opposed say nay. Mr. Clerk, for the next, it is advanced. Mr. Clerk, for the next item.
Madam President, moving to general file, First bill, Legislative Bill 1393, introduced by Senator Ben Hansen at the request of the governor. It's a bill for enacting the Nebraska Student Athlete Name, Image, and Likeness Rights Act to amend Section 48, 3602, 3603, 3604, 3608, Revised Act, CUMSUP 2022. Change provision related to name, image, likeness rights and limitations, civil actions, contracts, or agreements under the Act, provide severability, repeal the original sections, declare an emergency. The bill was introduced on January 17th of this year, referred to the Business and Labor Committee. That committee places the bill on general file with no committee amendments.
Senator Hansen, you're recognized to open on your bill.
Thank you, Madam President. Good afternoon, colleagues. The college athletics landscape changes every day, and it is with this in mind that I bring LB 1393. This bill provides institutions in Nebraska with an increased flexibility to adapt to changes happening on a national level in the arena of NIL student athletes. I want to take a more proactive approach in enhancing the student athlete experience and put every institution in the state in a better position to retain and recruit athletes. Currently, institutions work with student athletes in an arm's length capacity that is inefficient for the institutions themselves, as well as the companies, fans, and the student athletes. My purpose for LB 1393 would allow institutions to better utilize department resources and assist student athletes with NIL activities. Universities support students throughout their entire college experience, and it only makes sense to be able to offer direction if they ask for it when it comes to NIL. Next, LB 1393 would allow institutions to better activate existing relationships with corporate sponsors and partners. They would have the flexibility to take an active role through the process of NIL opportunities from introduction, creation, and fulfillment. Another aspect to NIL that has been a priority for the state of Nebraska is the protection of student athletes' information. We have taken steps to guarantee privacy through requiring students or the authorized companies to disclose NIL activities to a third-party software platform that we can review. However, LB 1393 expands our intentionality in protecting the private nature of the business relationship between student athletes and third-party entities by prohibiting terms of a student athlete's NIL agreement from being made public. And finally, LB 1393 prepares for potential changes that could come through the guidelines of NIL on a national level. To remain competitive, institutions in Nebraska will be able to compensate a student athlete for the use of the student athlete's name, image, or likeness, should that be allowed by a college athletic association policy change, court order, or settlement agreement. LB 1393 is clear, though. If a day comes when institutions can compensate student athletes for the use of their name, image, likeness, the fact alone does not make them employees of the institution. I've worked with the governor to create language that gives us the tools to recruit talent in Nebraska and keeps us take initiative for NIL opportunities in our state. I encourage your green vote on LB 1393. Thank you, Madam President.
Thank you, Senator Hansen. Senator Blood, you're recognized.
Thank you, Madam President. Fellow senators, friends all, I did speak with Senator Hansen on this. I want to get some things on record. I may speak more than once, but I am not trying to sink his bill. But I do want some things on record that we should all think about, because I know that the NIL is the Wild West right now. So right now I do stand in support of the bill, but have some questions. So I'm just going to run through my questions. If I don't have time, I'm going to punch back in. And there are things I'd like you to think about. So if we have an NIL collective like the 1890 initiative, which we have, and it's funded privately, is it redundant that we have the university directly involved in NIL using taxpayer money? For example, the university is hiring an attorney according to the fiscal note, but the 1890 initiative already negotiates contracts with athletes and organizations. So again, why are we potentially paying for an attorney separately with public money? What does LB 1393 do that the 1890 collective does not already do? And if it does complement the private collective, how so? Also, I think it should be noted that Mr. Kaborik, who is the CFO and the interim president, is the person who wrote the fiscal note for the university for the cost of an attorney. Now, it is permissive, by the way, but none of the other colleges requested an attorney for their portion of the bill. Why is that? Another potential conflict of interest I would like to highlight is, for example, an athlete that would like to take on a sponsorship from Nike, but the university is an official partner with Adidas. Would the university have a right to block this deal or allow such a deal to move forward? It would contradict with the whole idea of the free market. This also applies to Section 2, page 5, prohibiting students from entering into contracts or agreements with products reasonably deemed to be inconsistent with the educational mission of the post-secondary institution by such post-secondary institution. Can a student athlete not sign an NIL deal with a vape shop or some other company or product the university doesn't like if they conduct the agreement beyond the university's domain? Also, when the university is involved in NIL deals, does Title IX apply? Will an equal amount of money have to be paid out to female athletes in this case? The university being involved would likely trigger Title IX, I assume. Section 5 would bring opportunities for student athletes to bring litigation against the university. This would bring a lot of unwanted legal costs to universities already having fiscal issues. So friends, from the very start, when I read this bill, I immediately started writing down my questions. These are my questions. My staff has had conversations with the university, but I still question why the redundancy. And I don't know if it's because we were trying to get more hands in the cookie jar, and I don't fault the university from trying to generate income from this as well. The way it was presented to us by both the governor and the people who came from the university is that allegedly students come to them for advice and that they legally, as it is now, can't give them advice, which I don't disagree with. But I don't know why, when we had the Pede family putting so much money into the 1890 initiative, and it is a nonprofit, why a second level is needed. So for me, since I will not be here in the future, I wanted to get these questions on record in case anything were to happen with any of my concerns. With that, thank you, Mr. President. I'd yield back any time I have left.
Thank you, Senator Blood. Senator Wayne, you're recognized.
Will Senator Hansen yield to some questions?
Senator Hansen, will you yield?
Yes.
Senator Hansen, what is the purpose of this bill?
Well, I think what you're saying, this is in addition to a bill that Senator Hunt introduced, LB 962 in the 2020 legislative session. If you remember when she introduced the NIL bill to get it started here in the state of Nebraska. I believe, from my understanding, this is actually putting some guardrails in place in preparation not only for what the NCAA might be doing in the future, but also to enhance the relationship between the university and the student, to make, to help the university get involved if the student so chooses, if they need help with some certain things, to protect the potential litigation against coaches or staff if the student determines that they were not fairly compensated or didn't get their fair share because they didn't get enough playing time. And also to clarify in statute that students are not employees of the university, which is what you kind of started to see happen, I believe, in Dartmouth just like about a month ago.
Well, so that's the question I have is how do we statutorily not call somebody an employee for workers' comp purposes? And the reason I say that is because it's still a test that's done by the court. So I don't know how we can do that here. But my bigger question is why are we restricting the university?
Is that a question for me, right?
Yeah, that's a question for you. Why are we restricting the university?
In what way? How do you mean?
That they can't, well, it says in here, page 4, post-secondary institutions shall not compensate a student athlete for the use of their name, blah, 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 by association, post-secondary, court order, or settlement. What does that language mean, that they can't be compensated for college athletic associations and post-secondary institution policy?
I believe that has to do with potentially with the NCAA, some of the guidelines that could come down and protecting possibly the college.
Okay. My bigger question is, do you think we should wait and figure this out over the next 3 weeks until we get a new athletic director?
I think we are well within our bounds to take care of this now and answer any questions if we absolutely have to between now and select file, or when we hire another athletic director in between that time.
Okay. And in fairness, because I haven't sat down and talked to you about this, so I actually overlook a lot of contracts for NIL deals, so I'm kind of familiar with other states and what they're doing, particularly Florida. So because I was focused on a different bill this morning, I'm just not going to spend a whole lot of time on general file, but from here to select, if we could sit down and have some conversations, would you be willing to do that?
Yes, definitely.
Thank you. Thank you, Senator Hansen. So I'd like to yield the rest of my time to Senator Day.
Senator Day, you're yielded 1 minute, 57 seconds.
Thank you, Madam President, and thank you, Senator Wayne. I don't have much to say on this bill, but I do appreciate the time. And have a lovely Monday. Thank you.
Thank you, Senator Day, Ben Hansen, and Wayne. Senator Michaela Cavanaugh, you're recognized.
Thank you, Madam President. I am unsure about this. I wasn't honestly paying attention to it, but I was listening to Senator Blood's questions, and I am curious if this is necessary, because it creates a provision that no post-secondary institute should be prohibited from creating supporting student-athlete NIL activities or entering in with a third party to support those activities. Would Senator Hansen yield to a question?
Senator Ben Hansen, will you yield?
Yes.
Thank you, Senator Hansen. And I know you and Senator Wayne were having a little bit of a back and forth, but does this take any of the flexibility away from the student themselves to enter into whatever contract they want?
No, they can actually, student athletes can actually perform NL activities on their own.
Okay, so what does this do then?
I pushed my button later on to answer a lot of Senator Blood's questions, and so I can.
You can start now.
I can do it now, or I can. Okay.
You can start.
All right. So, because Senator Blood was kind enough to kind of come beforehand and ask me these questions that she also did before. So hopefully I can answer some of the best that I can. But she had some questions about the relationship between 1890 Project and UNL. She wants to know maybe what will change, what will enhance, why is it necessary, is there redundancy in what UNL will be doing? And the 1890 is a corporate partner of Nebraska Athletics through a multimedia rights partner called Playfly. The NIL bill gives all athletic departments in the state the flexibility to work closer with their corporate partners in the NIL space, and the end goal of recruiting and retaining the best student athletes in the state. The fiscal note she was talking about with an attorney. I think it's something maybe you mentioned too there. Why do we need it when maybe some other states haven't? The fiscal note, and this is also in conjunction maybe what the university was maybe talking about, it is speculative in that if institutions become more involved in the NIL space, more legal help may be needed to ensure the best interests of the university and the student athletes are being protected and all state, federal laws in the space are being adhered to. So I think it's kind of growing. It's kind of turning into a bigger thing, I guess. And so they're looking to protect themselves, not just the student athletes, but the university as well, by possibly having a lawyer if they need one.
Okay, I mostly just want to make sure that I know Senator Hunt brought this bill when it first was enacted and that we're not restricting their ability to negotiate on behalf of themselves.
Well, I had that same question before the bill was brought to me, because this is about the same time we were, having a new quarterback, come to the college. And I said, if this bill does anything to mess with that relationship or anybody's ability to get in the NIL space, I'm not going to touch that with the 20-foot pole. So, and from my understanding, this is a bill at the university and both the student athletes like.
Okay, thank you.
Yes.
Thank you, Senator Ben Hansen and Senator Michaela Cavanaugh. Senator Hansen, you're recognized.
Thank you, Madam President. I do want to touch on maybe a couple other questions that Senator Blood had. I think one of mine have been about open doors and why we have chosen them, what they do exactly. And Open Doors is an NIL software platform created by two former UNL former student athletes, and is actually the first one that was actually created in the country. And it's designed to market and connects athletes, both college and professionals, to fans and companies through a marketplace, similar to Etsy or eBay. It just kind of creates that connection portal between professional NIL student athletes and maybe kind of marketing opportunities. Let's see. I think that's the majority of her questions. I'll go back and ask her again to make sure I get all these answered if there are any more. So thank you, Madam President.
Thank you, Senator Hansen. Senator Hunt, you're recognized.
Thank you, Madam President. Would Senator Hansen yield to some questions?
Senator Hansen, will you yield?
Yes.
Thank you, Senator Hansen. Sorry I haven't grabbed you. Everyone's been asking you questions, and I've been kind of coming up with them as you're talking. So I know what Open Doors is. Can you explain what this bill would do for a company like Open Doors?
I
You,
can't.
in your last time on the mic, you said what that company is, which we know what it is, but what does this bill do to affect them?
Well, I would assume the more people, the more students that get involved in NL space, the more that Open Doors could be used to help market that athlete, to make sure they have opportunities available to them that maybe they didn't before.
For sure, but what does this bill do? That would happen regardless of your bill passing, right?
It could, sure.
And what was the name of the other third party?
The 1890?
No, not that one. There was like a software company or something you mentioned.
Yes, that was the multimedia rights partner that the Nebraska Athletics goes through. Is called Playfly.
Playfly. What does your bill do to, if the bill passes, does this somehow encourage the use of Playfly, or can you speak more about that?
I think so. From my understanding, it doesn't like encourage it, but that is just another avenue that the university uses that could be in conjunction with possibly the 1890 or Open Doors.
Right.
I hate to. I don't want to make sure I don't give you the wrong answer.
Right.
So
I guess the thing that's always confused me about this bill is, since I saw you introduced it, to we had the hearing, to we heard the testimony, to now, is I am not clear, and I may be, I mean, I'm not an attorney and I'm not, I'm not an expert in this world at all, so maybe I'm just dense or ignorant, but like, I am not clear on how anything that your bill seeks to accomplish cannot already be done. Is there anything, I mean, if this bill doesn't pass, is there anything preventing the University of Nebraska from putting the guidelines or the stipulations of your bill into their own policies at the institutional level?
I'm unsure, I guess, but I think the biggest thing is making sure is the part, especially that we want to see in statute, has to do with possible litigious action that could happen when it comes.
Have there been any examples around the country of like what you're talking about, like a student not getting enough playtime and then they sue the coach because they didn't get the Gatorade sponsorship because they weren't on the field long enough? Has that happened yet?
I'm unsure.
Okay, I'm curious about that.
I can look that.
I don't know, a lot of, and I'm not hating on it. I mean, I originally introduced LB 963. That seemed like the country was kind of going that way. The first bill was passed in California, and then we introduced 963 here, and then we had COVID and all that, but in the middle of all of it. But, I came into this thought, this paradigm of name, image, and likeness as an entrepreneur, not as a sports fan, not as like, I want to see my favorite athletes sponsored by Gatorade, but as in, I want the setter on the women's volleyball team to be able to post sponsored content on Instagram, like every other girl in college. And to me, it's a bill for entrepreneurs. It's not a bill to, that's just my view of it. But reading through the bill, I just confess, as I said, I don't understand how any of these things can't already be done by institutions if they choose to.
1 minute.
Thank you, Madam Chair. And I think I'm done with questions. I'm sorry. So I would love to stand to be corrected. I would love to have that explained to me. And I also am wary of the mention of third-party software and organizations and institutions in the bill language because, my view is that if these third-party software like Playfly or Open Doors, if these companies are good and effective, we don't need legislation to encourage institutions to use them. They'll just be used. And anytime there's language in a bill of like, cannot prevent, cannot prohibit, I don't know, I think it's just squashing the free market a little bit, to be honest. And I think these things can play out and work themselves out without a bill. Thank you, Madam Chair.
Thank you, Senator Hunt. Senator Conrad, you're recognized.
Thank you, Madam President, and good afternoon, colleagues. I am equally ambivalent about the legislation and wanted to perhaps raise a few questions with the introducer as I try and learn more about this, as I'm not a member of the Business and Labor Committee, and so I didn't have the opportunity to think through it quite as deeply as those members who heard the live testimony and then exec on it. I'm wondering if perhaps Senator Hansen would yield to some questions, please.
Would Senator Hansen yield to a question?
Yes.
Thank you so much, Senator. I remember watching Senator Hunt's efforts in regards to establish this NIL program in Nebraska many years ago, and I know many other states have moved in that direction, and it's been really exciting for a lot of our student athletes and has generated a lot of attention in the political realm as well. So I know that recently Senator Pete Ricketts has talked about some of the work or loopholes or additional provisions that he would like to see perhaps to these programs on the federal level. And, one issue that's popped up a lot is how this impacts student athletes that are here on a student visa. So could you talk to us a little bit about that?
That's a good question.
Okay. Well, I did ask it, so I appreciate the compliment.
All right. How that would specifically affect someone with a visa, boy, I'd have to
That's okay.
I'd have to clarify that a little more for you off the mic.
No problem. And I'm sorry, I think that our agenda was moving a little bit faster today than perhaps we all anticipated when we came in. And so we didn't have a chance to have the organic conversation with 137 being pulled off the agenda. I think everybody was anticipating that we'd have about 2.5 hours left on that. So we're moving a little bit more quickly than we had originally thought. We can definitely check on that in between general and select, but I did want to note that for the record, because I know that has been an issue for some of our players. And I'm thinking of, I think, is it Jazz Shelley or some other student athletes that are here on a student visa, and they may not have the ability because of immigration restrictions to partake in NIL. So I'm trying to understand the intersection between federal law and immigration law and NIL as well, and didn't take sports law in law school. So I'm at a bit of a deficit, but that's one that I wanted to pose for the record. And then the other questions I had perhaps are more straightforward, but why is this measure brought on behalf of the governor?
I'm thinking off the top of my head, and I'm trying to remember, like, when we first had our meeting, what the original intent was. I know the intent was also because it was to protect university and students and their, and so
okay.
Why on behalf of the governor specifically? Again, that I don't know.
Yeah. Okay. Very, very fair. Thank you for your candor. And then just really a couple of other questions. Senator Hansen, if you know, how does this particular bill harmonize with efforts that are concurrently working their way through the NCAA, or as I mentioned, on the federal level? And if we have a sense about where we stand in regards to our sister states, because I think this is very complex. And I want to have an understanding about how this particular measure ensures that we're on an equal playing field, pun intended perhaps, in the context of this debate, or I'm just trying to kind of understand the interplay with other state law, NCAA rules, and federal law. And that's a lot to cover in a minute, so I can punch it again.
Thank you. I think you addressed the rub. I think that's the thing what we're trying to keep up with. I think it's a little bit of a moving target right now.
Okay.
What the NCAA is trying to do, and you're trying to read the tea leaves a little bit here on maybe, hey, look, they're going to be doing something next year. They're going to do it more on a national level. But right now, since they're not taking some of those actions, I think the university, is trying to find some way to kind of make this work in a more cohesive fashion with the student athletes and the university administration. So I think that's where some of this is kind of where the purpose of some of this bill is, to see some of those moving targets and move along with where NIL is going, with the hope that eventually then on a more kind of national level, some of this will be taken care of.
Okay, very good. I think we're out of time, Senator Hansen. So I punched it again. I just have 2 more questions, and I appreciate your dialogue. Thank you, Madam President.
Thank you, Senator Hansen and Senator Conrad. Senator Erdman, you're recognized.
Thank you, Madam President. Let me just announce that when you're in the chair, I really appreciate it. I can hear you well. Nice job. So let's talk about NIL a little bit. Several weeks ago, Coach Saban, Alabama football coach, was talking about NIL on ESPN. And his comment to the interviewer was, in the past, before nil, the prospective player would show up at Alabama and they would ask 15, 20 questions about where do they live, who's going to be their position coach, those kind of questions they had about all of the issues, what's the cafeteria like, the weight room, all those questions they had about coming to the University of Alabama. He said after nil became prevalent, they had one question: what are you going to pay me? They didn't ask any questions about any of the other issues, just how much are you going to pay me? We have young people, and I mean young people who are still in high school, who are getting nil payments. So what we have done is we've made professionals out of these young people, and it's no longer are they playing the sport because they love the game. They're playing the sport because it's how much money they can make. So I contend that we didn't do ourselves any favors by implementing this program. And then we have expanded the portal when they can change schools. So what we have now begun to develop is we have developed the same kind of thing that baseball has. We're developing young people in these universities to fill in the professional league. And so some of these young people will make more money under the current program in college than they will when they go to the professional leagues. I don't know that this was well thought out when we put this in place, but it has changed the way college sports are played today and who's playing them. So it's a peculiar situation we find ourselves in. Nothing we can do here today is going to change that. I think it's something we need to consider when we make these kind of decisions in the future about what are the ramifications. And I'm sure we didn't think this one through well enough. Thank you.
Senator Conrad, you are recognized to speak.
Thank you, Mr. President, and thank you again, colleagues. We just ran out of time on my earlier point at the mic, but I'll tell you, in looking at some of the relevant documents in relation to this legislation, it strikes me as odd. I don't know if this is a model bill that somebody's shopping around or exactly where this came from, but it seems very strange to me that there's a repealer on this, an E clause on this, and a severability clause on this. Usually that's kind of or should be a red flag that maybe you're trying to plunk something into Nebraska state law from a model bill. That does happen from time to time for different reasons. But if that's the case, I just want to get some clarity on the record about where this model legislation or this legislation originated from and why, so that we can evaluate those considerations. And it also shows me that there's probably a significant amount of legal questions, perhaps, attendant to the measure if we're having that kind of protective drafting. So if Senator Hansen would yield a few more questions, and if we don't know today, we can put them on the record and put our heads together from general to select, which I appreciate and understand. If Senator Hansen would yield.
Senator Hansen, will you yield?
Yes.
Okay, thank you, Senator Hansen. So essentially, this measure seeks to change the legal relationships between student athletes, NIL entities, the university, and other parties. Is that your intent?
Yeah, I tried to get a little more clarification on, I think it was a question maybe you had or somebody else had about kind of legal ramifications, not only about protecting the university and the students, but right now I think it has to do with the guidance that the university can give students. Right now, I think they're restricted from giving any kind of guidance like they would in every other situation with the university. This then, because the university is very limited on any kind of guidance or advice they can give students when it comes to NAL. And so from my understanding, this bill then kind of helps open that up a little bit so then it can be more communication like there is in every other thing.
Okay. And then it does provide legal immunity for university officials, which is always something that we should carefully consider as well, that I think we need to kind of work through. I know that this has been another topic because I think we just have to be careful with the grant of immunity. And I'm a huge champion for the university. It's a big part of my district, but from a legal perspective, that's something I want to think carefully about. I know that this has been part of the dialogue perhaps nationally, but is this directly an effort to thwart the ability of student athletes to organize under the National Labor Relations Act?
Now, the right to organize, I'm unsure. I think we're just spelling out the fact that they're not employees of the university.
Right.
Now, what kind of ramifications? I'm sure I can get some more clarification on that.
Okay. I think
and
that
so
would be good.
like I mentioned, I talked with Senator Wayne off the microphone too. He had some questions as well. It might kind of pertain to some of that stuff since he's been doing some of the contract negotiations and stuff like this before. And so we're going to kind of make sure he gets all of his questions and answers as well. And I'm do the best I can answering right now as well.
Okay. All right. And it's probably not a commonplace kind of consideration for an elite level student athlete who's going to have a variety of perhaps competitive offers for NIL purposes. But is there any sort of sense about how NIL income is treated for purposes of scholarships or financial aid or other kind of related issues that students might be working through or thinking through?
From my understanding, no. I don't, this bill doesn't change any of that. I think that all kind of remains the same. This shouldn't affect any of that stuff, from my understanding. And because that was a question that I similarly had when we sat down with some of this, is will it affect scholarship money that they're getting in or tuition that they're going to be paying in, housing, other kinds of stuff? And from my understanding, no.
Okay, thank you so much, Senator. I'm willing to vote yes today to advance it, but I appreciate your candor. I'd be happy to sit down in between general and select, but I think there might be a little bit more to this legislation than meets the eyes at first blush. Thank you so much.
Senator Vargas, you are recognized to speak.
Thank you very much, Speaker. So I have a few questions for Senator Hansen, if he could yield. There's similar questions that Senator Conrad was asking because, and I'll preface this, I had similar questions about the employee component. There's some language in here that sort of clarifies that they shall not be deemed as employees. And the reason why I kind of wanted to ask Senator Hansen about intent. Is the intent of this legislation to be a precursor of not allowing student athletes to be classified as employees?
Senator Hansen, will you yield to a question?
Yes, I want to make sure I heard you right because I was just getting some clarification and making sure I wasn't missing something. Yeah. But yes, they cannot be employees of the university.
So the reason why I have a question about that is if they can't be employees of the university, then legally they don't have and they can't appeal to the National Labor Relations Board and are not deemed, are not able to even be classified or have any rights under the National Labor Relations Act. And recently, Dartmouth men's basketball team, they just convinced the NLRB regional director that they are employees under this act. And there's still U.S. Court of Appeals. There's more decisions that are coming. There's a lot of this that I don't disagree with in terms of cleaning up the sort of name and likeness acts and what you're trying to do. I am concerned, and we'll dig into this more between general and select, that if we are preempting and saying that they're not employees rather than letting the court system do this, we're already telling them that they can't organize if there is a need to organize. And I'm not sure if it was the intent of the legislation to preempt it or if it's just trying to clarify what is already understood under law. And so that's a question.
Yes, and I got some clarification on that. Senator Conrad had a question about that. Yes, they can join a union. I was unsure on whether they could or not. That's a question she had on whether they can organize and join a union. They can.
Okay.
I'm gonna look into that, because my understanding is that they would not be able to, if they can't be deemed as employees, that they would not be able to. But I will look into that more. I'm still not sure about the legislation, again, mostly because I'm digging into it a little bit more, and I'm trying to have a better understanding. And because there's a lot of federal legislation that's been introduced, there's been more court cases that have been brought or being brought to the U.S. Court of Appeals. And the Supreme Court can later weigh in on this, but it is a conversation on whether or not these individuals are deemed employees. And if they're employees, they have more rights that are enabled to them. And if this is trying to preempt that, I don't necessarily think I agree with that, because the conversation right now being had in universities is whether or not they get ahead and just say, yeah, we deem them as employees and we give them some rights. And so I'll look into it more, but I appreciate you, Senator Hansen, and thanks for answering my questions.
Senator Hansen, you are recognized to speak.
Thank you, Mr. Speaker. So in just kind of closing, I just want to, I appreciate all the questions that we are getting here. I think this is a conversation that we do need to have, not only because it kind of is a new subject in college athletics, but I think some clarification needs to be had just now within our state, but maybe because the lack of clarification from a national level, that we have to do our due diligence as a state and make sure language is correct and make sure we're doing everything we can to protect the student athlete and the intent of the bill itself with NIL. So appreciate all the questions. I'm gonna get together with other people in between now and select file, make sure I answer everybody's questions to the best that we can. So thank you, Mr. Speaker.
Senator Blood, you are recognized to speak.
Thank you, Mr. Speaker. Fellow Senators, friends all, I am circling back to what I initially started with and would ask that Senator Hansen please yield to a question.
Senator Hansen, will you yield?
Yes.
Senator Hansen, I've been listening to all the other concerns in your responses, and thank you, by the way, for your responses. But I'm still not hearing about Section 2, page 5, about the way I read it would prohibit students from entering into contracts or agreements with products reasonably deemed to be inconsistent with the educational mission of the post-secondary institution by such post-secondary institution. How is it legal that student athlete cannot sign an NIL deal with, say, like, the example I used was a vape shop, it could be birth control, it could be alcohol, and if the university doesn't like it, then they would not be able to move forward on that contract. How is that legal?
Yeah, and I remember this is a question I believe you asked during the hearing as well. And the answer, from my understanding, is to create alignment with the student and student athlete code of conduct at the institution, so they're not, and the athletics department, so they're adhering to the codes of conduct of the university, as well as, what they're trying to accomplish with NIL. So from my understanding, that's what they're telling me, is to create alignment with that code of conduct. So they're not breaking a whole bunch of what the university's rules are in order to get NIL money.
So the thing that concerns me, and I think I probably talked about this in the hearing too, and I thought it was so puzzling that the governor was there on this, by the way, which really was my first red flag. If it's their likeness and they're selling who they are, why should we be involved with that?
Is that a question for me,
That's
right?
the question.
Okay, all right, just
That
making
is my
sure.
question.
And this will kind of go back to my opening, right? I believe the idea is that we're trying to address a moving target, put some good guardrails in place to make sure privacy is protected, information is protected, the student is getting what was rightfully theirs, to make sure we can kind of open up that line of communication between the university and the student. Some clarifications I think that need to happen in this bill because of some of the things that are happening nationally, because of that we're starting to see what the NCAA may or may not be doing, and to make sure that we can also be competitive and take the initiative in the NIL space, because as the NCAA expands, we want to make sure that we're not limited as well.
And that's fair, but again, I go back to, we already have the Pede family in the 1890 project. And to me, reading the bill, it just feels like more people are trying to get their hands in the cookie jar, because obviously the university will make money by doing this. It won't just be a goodwill gesture as they try to impress upon us in the hearing. It's going to be an actual initiative of the university with paid staff. Is that not correct?
From my understanding, the university doesn't really make very much money off this at all,
Doesn't make very much. What's not very much?
or maybe not at all.
Okay,
I can clarify that for you
think-
again if there's something I'm missing here, but
I think we might need to address that. I
Yep.
think the way it's written, there's potential for that. So, and I wasn't trying to do that as a gotcha question. I really am trying to have a dialogue with you.
and I'm
So
trying to answer it best I can too. So if I can follow up with you too on that, just to make sure.
I'm still puzzled why we need a second entity when we have an entity in place that's already doing this. And that's the concern that I have. And I understand that they're two totally separate entities, but why are we being redundant? And I do understand, again, and I say this, it's a Wild West kind of thing with the NIL, and people are trying to get it right, and things are moving really fast. But sometimes I question certain motives, and I just want to make sure that whatever we're doing it something that is for the betterment of the university as a whole and not for certain individuals that are getting involved. So with that, thank you for those answers, Senator Hansen. And I would yield back any time I have to the speaker.
Senator Hunt, you are recognized to speak.
Thank you, Mr. President. I'm going to be present, not voting on this round on LB 1393. As far as I can, and again, I said in my last time on the mic, I find the bill confusing and redundant. And it sounds like even after the question and answer that we've had with the introducer, Senator Hansen, there's still a lot of unanswered questions. There's a lot of things that respectfully he doesn't know about the bill either. Not that it's not knowable, not that we can't figure these things out between general and select, but there's questions about the necessity of the bill. I come down on the side that it's not necessary. It seems like, to my reading, as a amateur bill reader who's been here for 6 years, the things that LB 1393 changes to our NIL system that we already have in statute, which is broad, but was tailored, through negotiation and compromise with colleagues in the legislature. It prevents athletes from being classified as employees, which they aren't. And it prevents athletes from suing coaches, which it sounds like they aren't. And at the end of the day, the University of Nebraska or our state college system or whatever, none of these institutions need permissive legislation to enact NCAA guidance. If we're saying, well, things are coming down the pike from the NCAA, there's going to be different rules and regulations. Okay, but we don't need permissive legislation in place from the state to have those go into effect. Institutions will already be able to do that without a law being passed. And so that's why I worry about the effect of restrictive bills like this on the market when the goal of NIL is to allow these students who are adults to participate in the market with their own skills and talents, their name, image, and likeness, their athletic ability, the same thing that all other students are allowed to do with their own abilities and talents. The only difference is that because these kids play for NCAA teams, that they have these restrictions put on them that other kids don't face. And to me, that's a problem with the market that I believe we attempted to solve already. And I see LB 1393 respectfully as putting further restrictions on that market that aren't necessary and that could, restrict the market in a way that harms these kids and kind of goes against all of our goals with NIL in the first place. Open to being convinced otherwise, but from my reading of the bill, from sitting on this committee where this bill was heard, from listening to the testimony, and from listening to the floor debate today, that's where I still stand. Thank you, Mr. President.
Seeing no one in the queue, Senator Hansen, you're welcome to close on LB 1393.
Thank you, Mr. Speaker. I know one of the words that we're kind of hearing here is redundancy, like this is redundant. I think this is almost the opposite of being redundant. I think this is because we are a separate entity than the 1890 Project and Open Doors. We are separate from them. And so just like they protect themselves, I think as a university, we have to protect ourselves as well and also protect the students in a separate manner. And that's what this bill does. It tightens up the original bill that was introduced and passed, a few years ago. This helps kind of change with some of the times that we're seeing on the national level. And so I think this is a very warranted bill. And I may not have all the answers to everyone's very specific questions in a complex atmosphere such as NIL. Doesn't mean, respectfully, Senator Hunt, I don't understand my bill. I get maybe where I'm not answering the questions the best, but I'm going to do my best to make sure, that we do get all those questions answered, that I can answer them the best I can here. And I feel like it did for the majority of them. But I just want to make sure that I don't feel like this is redundant, because a lot of things that we're doing is on the university's behalf, and we're not doing it on behalf of anybody else. And we want to make sure that the students are protected along with the university. So I appreciate everyone's green vote. And like I said, I'm going to go around and answer everybody's questions. Some other ones that they had, more specific ones, the best that I can between now and select file. And if there's any other questions anybody else has, don't be afraid to approach me and we'll do our best. So thank you, Mr. Speaker.
Thank you, Senator Hansen. You've heard the closing, colleagues. The question is the advancement of LB 1393 to E&R initial. All those in favor vote aye. All those opposed vote nay. Have you all voted? Mr. Clerk, please record.
29 ayes, no nays on the motion to advance the bill.
The bill advances. Mr. Clerk, for items.
Thank you, Mr. President. Your Committee on Enrollment and Review reports Legislative Bill 358A, 685A, 857A, 905A, 1035A, and 1087A, all placed on final reading. Enrollment and Review reports Legislative Bill 1412 to select file with amendments, 1413 select file with amendments, 644A, 904A, 1204A, 926, 880, all to select file. Finally, communication from the governor, Legislative Bill 61, 198, 304, 771, 771A, 844, 895, 938, and 1104 have been signed and delivered to the Secretary of State. That's all I have at this time.
Thank you, Mr. Clerk. Please proceed to the next item.
Mr. President, next bill, Legislative Bill 1088, offered by Senator Linehan. It's a bill for enacting the Nebraska Advantage Act to change the time period in which required levels of employment and investment must be met for certain projects, provide for applicability to harmonize provisions, repeal the original section. The bill was introduced on January 9th of this year, referred to the Revenue Committee. That committee placed the bill on general file with no committee amendments.
Senator Linehan, you're recognized to open on LB 1088.
Thank you, Mr. President. Good afternoon, colleagues. LB 1088 changes dates for levels of employment for approved projects under the Nebraska Advantage Act submitted and approved after December 1, 2020. These changes are made within Chapter 77, Sections 5327 and 5727. LB 1088 will ensure that sustainable beef can meet all the requirements under the Nebraska Advantage Act. Sustainable beef is a beef processing facility located in North Platte with over 500,000 square feet and over $400 million in investment. This project will process 1,500 cattle per day is the best option for Nebraska cattlemen to have ownership in a packing plant and will bring more than an estimated $1.2 billion to Nebraska, and more specifically, the North Platte area. Last and most importantly, this project is bringing 800 jobs to Nebraska. Sustainable beef applied and was approved as a Tier 6 project under Nebraska Advantage Act in December 2020. As a Tier 6 project, sustainable beef must meet employment requirements in 4 years. LB 1088 would extend this deadline to 6 years. The Sustainable Beef Advantage Act application was made during the COVID pandemic, and as you all know, with COVID restriction, the world was a different place in 2020. The project experienced delays due to supply chain issues and financial due diligence created by COVID. Due to virtual meetings and instead of in-person meetings and the desire for investors to monitor COVID impact on the marketplace, there was an unexpected hardship on this project. Based on these factors, the project open date has been pushed back from July 2024 to July 2025. LB 1088 would allow the project to resume its intended financing expectation. The state of Nebraska has already appropriated and planned to issue credits approved under Sustainable Beef Agreement, so there should not be an unexpected fiscal note to the state. This project is greatly important to the state of Nebraska. Sustainable beef is critical to Nebraska's farmers and ranchers, and the current incentive approvals, and specifically the changes in LB 1088, will keep the project in the hands of Nebraska owners and on the same path and financial trajectory as intended from the application in 2020. I would ask this body to support LB 1088. It came out of committee 8-0. There were proponents at the hearing. There were no opponents and not even anyone in neutral. Also, proponents were Nebraska Cattlemen, Nebraska Farm Bureau, Nebraska Corn Growers Association, Nebraska Pork Producers Association, Nebraska Dairy Association. These were letters, Platt Institute, and the Nebraska Cooperative Council. Thank you, Mr. President.
Senator Erdman, you are recognized to speak.
Thank you, Mr. President. I wonder if Senator Linehan yield to a question.
Senator Linehan, will you yield?
Certainly.
Senator Linehan, so I see this is an extension of the Nebraska Advantage Act. Is that correct?
They applied under, it's not an extension of the act, it's an extension for this group only because of COVID.
Okay, so would they not be eligible for the Imagine Act?
They applied before, evidently before the Imagine Act was in. There was a year, I get my years confused, Senator Erdman, you can help me. Do you remember when we passed 1107? Was that 2020? I think it was, right?
Yeah, I think it was 2020.
It was the last project.
So it was one of the last projects approved under the Nebraska Advantage before we moved to Imagine in 2021.
Okay, so they applied in 2020, but because of COVID and whatever else, and we adjourned and we didn't act on it, then the time ran out. And so then this is just an extension of them making the application for the Advantage Act, right?
Right. And you'll remember Senator Jacobson, if he wants to punch in and get up and help me here, but this was all tied into Senator Groney and the railroad spur. And
right.
It was a big project for North Platte because, as you know, North Platte has lost a lot of jobs over the last decade.
Yeah, yeah. Okay, thank you very much. Appreciate it.
Thank you, Senator Urban.
Senator Jacobson, you are recognized to speak.
Thank you, Mr. President, and thank you, Senator Linehan, for bringing this bill. And thank you, Senator Erdman, for the questions. The way this worked is that I believe this was the last project that was approved under Nebraska Advantage. And that program had certain benefits that, of course, the new programs don't have, but it was approved under the Advantage Act. Then, as they moved forward trying to get the project moving, it took longer because of the pandemic and all the processes. Meanwhile, their costs continue to go higher and higher. They're running close to double what the original projected costs were going to be. So the Nebraska Advantage Act really deals with, to get to Tier 6, the timing of when you hire those employees. And so because they've gotten pushed back, they're wanting additional time to still meet the Tier 6 guidelines. So that's what this is. It's not being late to the table to apply for the program. They were approved for the Advantage Act. This is allowing them additional time to meet the requirements that were set up to receive the full benefits from the Advantage Act. And also, if anybody's familiar with the Nebraska Advantage Act, there are sales tax dollars locally that have to go towards repayment of the state for the Advantage Act. That was unique to that program. So there is certainly big time participation by the city itself, as there is in a lot of the infrastructure, particularly sewer, electricity, and natural gas. So major project for the region. And what they're trying to do is maximize what they were approved to do and would have done had they not been slowed by the pandemic. And so this is just allowing them to get what they originally thought they were going to receive had it not been for the delays. So I hope that answers any questions that might be out there, but I would certainly respond to any other questions. Thank you, Mr. President.
See no one in the queue. Senator Linehan, you are recognized to close. Senator Linehan waives close. Colleagues, the question before the body is the advancement of LB 1088 to ENR initial. All those in favor vote aye. All those opposed vote nay. Has everyone voted? Mr. Clerk, please record.
37 ayes, no nays on the motion to advance the bill.
LB 1088 advances. Next item, Mr. Clerk.
Next bill, Mr. President, Legislative Bill 1031, introduced by Senator Bostelman. It's a bill for an act relating to telecommunications and technology to change speed test requirements for ongoing high-cost support from the Nebraska Telecommunications Universal Service Fund, change defined terms relating to the lease of dark fiber by any agency or political subdivision of the state and broadband services, change legislative intent to harmonize provisions, repeal original sections, declare an emergency. The bill was introduced on January 5th of this year. It was referred to the Transportation and Telecommunications Committee. That committee places the bill on general file with committee amendments.
Senator Bostelman, you are recognized to open.
Thank you, Mr. Speaker, and good afternoon, colleagues. LB 1031 is the second of the Transportation Telecommunications Committee priority bills. Primary purpose of LB 1031 is to make sure that public funds that come directly from Nebraskans are well spent. Currently, Nebraskans are subsidizing old copper-based telephone infrastructure that's become obsolete. This infrastructure is not capable of delivering access to internet services at speeds necessary for today's basic services like education, behavioral health care. The COVID pandemic brought this unfortunate fact to light. Nebraskans all over the state lack access to critical services. They are also missing out on opportunities to work remotely, especially in technology-based industries. They're not able to sell products and services from their ranch homes to augment ag income, and they, or we, miss out on cultural and social activities now available on those with access. Colleagues, we all agree we need to attract people to Nebraska. Despite all of the opportunities in our state we have to offer, we will not attract people, especially young people, unless they can keep connected with the rest of the world. Several large telephone companies have not replaced their copper network with fiber, even though they have received direct subsidies to do so for the past 25 years from both Nebraska and the federal government. They continue to receive subsidies from Nebraskans to support infrastructure that has long been obsolete. My legislation is intended to do two things. First, give incumbent telephone carriers a deadline to replace copper networks in areas they are committed to continue to serve, and two, to stop public support to those incumbent carriers for areas where they have not upgraded their network. This should help open up these areas to market entry competition, a goal of several bills that I have introduced, which this legislature has passed. Any public support the incumbent once receives should be redirected to the competitive carrier committed to serve the area. And before I go further, let me explain some basics. This legislation opens up provisions of the Nebraska Universal Service Fund, or NUSF. NUSF funding comes from Nebraskans who pay a monthly surcharge on their telephone bills. The Public Service Commission administers NUSF and has done so since the 1990s. The purpose of the 1997 NUSF Act was to connect all Nebraskans to voice telecommunication services and things that we then called information services. Eventually, we called it the internet. Now we commonly refer to it as broadband. Since the beginning of the NUSF, well over $800 million has been paid to incumbent telephone providers to provide telecom and broadband services to their customers. Under Nebraska laws, those incumbent carriers had the duty to serve all customers. This duty is called the carrier of last resort, or COLR obligation. In my mind, incumbent carriers that are not currently offering access to broadband have failed to satisfy their COLR obligation. We should not be providing subsidies to providers that are not complying with their duty under Nebraska law. Under the NUSF program, as it now operates, incumbent providers receive what is called ongoing support. This support is critical to the long-term sustainability of our broadband network. In rural areas of the state where there are few customers, the cost of operating and maintaining the network far exceeds what any provider will receive in customer revenues. NUSF support is vital to fulfilling the high cost gap. I am a proponent of the NUSF. It is critical to long-term sustainability of the network, but support should be used to help defray the cost of infrastructure that's actually capable of meeting modern needs of our customers, of their customers. I have worked over the past few years to make sure that the requirements of state programs funding broadband are uniform. To receive government support, infrastructure must be capable of access to broadband services at speeds of at least 100 megabytes per second for downloading and 20 megabytes for uploading. Some programs require symmetrical 100 speeds to qualify for funding. These speed standards apply to all state funding programs except when it comes to NUSF ongoing support. Currently, to receive ongoing subsidies, speeds need be only 25.3. We are using public funds to support infrastructure that is obsolete by all other standards. This infrastructure consists of copper that should have been replaced by fiber. My objective of LB 1031 is to stop government funding for obsolete infrastructure. After the hearing of LB 1031, a number of broadband providers and I negotiated an amendment to the original legislation, which the committee adopted. Specifically, the bill ends support for obsolete infrastructure 18 months after the legislation becomes effect. It also creates an exception for that 18-month cutoff date. If the carrier receiving ongoing support is in compliance with a federal obligation to deploy broadband infrastructure to any location, it will have until January 1, 2029 to fulfill that obligation without losing NUSF ongoing support for that location. A number of carriers recently elected to receive federal funding under a program called ACAM. It is those carriers that will be accommodated by the amendment. They will continue to receive ongoing NUSF so long as they continue to comply with their obligations under the ACAM program and complete fiber deployment before 2029. And finally, during the hearing on the bill, there were questions whether the company would lose support if all of their networks were not capable of 120 speeds. This amendment clarifies that they would only receive ongoing support for their networks capable of 120 speeds. LB 1031 also increases speed requirements in the last few remaining sections of statute defining broadband to harmonize speeds with the rest of our statutes. These sections relate to dark fiber and the leasing and the work of Nebraska and the work of the Nebraska Rural Broadband Task Force, which I am a member. LB 1031 and AM 2780 were voted out of committee with an 8-0 vote. I ask for your green vote on LB 1031 and the soon-to-come amendments, and I look forward for the discussion. Thank you, Mr. President, or Mr. Speaker.
As the clerk has indicated, there is a committee amendment. Senator Bosman, you're welcome to open on. Senator Mosier, you are welcome to open on the committee amendment.
Thank you, Mr. President. The Transportation and Telecommunications Committee amendment to LB 1031 makes one change in 1031 as introduced and also amends the provisions of 6 other bills heard by the committee into LB 1031. The original Section 2 of LB 1031 is amended by substituting language that directs that beginning 18 months after the effective date of the bill, the Public Service Commission shall not provide ongoing high-cost support from the Nebraska Universal Service Fund to any location not capable of receiving internet access at speeds less than 100 megabits per second for downloading and at least 20 megabits per second for uploading, unless that location is subject to a federally enforceable commitment to provide infrastructure providing broadband speeds at the 100/20 megabits per second. Beginning January 1st, 2029, the Public Service Commission shall provide no high-cost Universal Service Fund ongoing support to any broadband service location not capable of providing 100/20 speeds. In addition, the committee amendment adds the following bills: LB 865, LB 1038, LB 1255, LB 1256, and LB 1180. LB 865 was introduced by Senator Bosselman and provides that on or before June 30, beginning this year, every broadband provider in the state shall report to the Nebraska Broadband Office information regarding standard internet service plans advertised by the provider and the rates associated with the plan. There was no public opposition at the hearing, and the committee added 865 to the amendment on an 8-0 vote. LB 1038 was introduced by Senator DeKay and revises the membership requirements for the Nebraska Information Technology Commission. The commission has 5 members representing the general public. The bill requires that one of these such individuals shall have agriculture as their principal business or occupation. There was no opposition at the hearing, and LB 1038 was added on an 8-0 vote of the committee. Also included LB 1180 as introduced by Senator Wishart. It makes 2 changes to the telecommunication equipment program, which is administered by the Public Service Commission. The bill makes 2 changes to the eligibility requirements under the program. Individuals eligible for equipment assistance, that section is changed from 1 person per household to 2 persons in a home. And the time period for when an individual may reapply for new equipment assistance is changed from every 5 years to every 3 years. There was no opposition to the bill, and the committee added this bill as an amendment on an 8-0 vote. LB 1255 was introduced as amended, was introduced by Senator Frederickson and revises the 911 Service System Act by adding new requirements for originating service providers and telecommunications relay service providers to connect and route all 911 calls to next generation 911 system to be answered. As amended, unless the FCC requires a different date, originating service providers, relay service providers, and the next generation service contractors shall ensure all 911 calls are delivered to the next generation 911 points designated by the state 911 director no later than January 1st, 2026. An originating provider or relay provider may agree with the state 911 director to establish an alternative date to comply with translation and call routing requirements. Also, 1256, LB 1256, as amended, was introduced by Senator DeBoer. The amendment substitutes for the bill and creates a new section on the 911 Service Act that provides any communication service provider
required to file service outage reports with the Federal Communications Commission shall also file copies of the reports with the Public Service Commission. The service providers must follow the same timelines as required by federal law, and the FCC reports are not to be publicly disclosed by the PSC. When the PSC obtains a report, a public hearing shall be held within 90 days. The Public Service Commission may delay a hearing, but not for more than 30 days. A majority of the PSC may waive the hearing, or the hearing will be waived if the service provider withdraws the initial report filed with the FCC. Both LB 1255 and LB 1256 were amended into the amendment on 8-0 votes of the committee. There was opposition to both bills, but amendments made by the committee amendment were made in response to the concerns expressed. I do understand Senators Frederickson and DeBoer may have follow-up language to add that will further clarify the intent of both LB 1255 and LB 1256. I would be happy to answer questions and welcome any comments that the individual bill sponsors would like to make to the T&T committee amendment to LB 1031. I would ask for the adoption of the amendment. Thank you, Mr. President.
Mr. Clerk, for an amendment.
Mr. President, Senator Frederickson would move to amend the committee amendments with AM 2905.
Senator Frederickson, you are recognized to open on AM 2905.
Thank you, Mr. Speaker. So as Senator Mosier had mentioned, there are some amendments to this to help clarify some language to ensure that all the stakeholders involved are on board with what we put forward. So AM 2905 amends the portion of the committee package that includes LB 1255, which is a bill that I brought this session to speed up and streamline the migration to the next generation 911 system and to eliminate one of the problems leading to recent 911 outages in Nebraska. This part of the committee package ensures that, and are you ready for this? This is quite a mouthful. It ensures that originating service providers in the next generation 911 service contractor shall cause all 911 calls to be transmitted to the next generation 911 network that allows 911 calls to be answered and cause all translation and routing to be completed to deliver all 911 calls to the next generation 911 network that allow 911 calls to be answered. That is a very jargony and robust way of saying this will ensure migration from the legacy 911 system to next generation 911 in our state in a timely manner. As many of you are aware, Nebraska has had a problem with 911 outages, particularly in this past year. The Public Service Commission is conducting an ongoing investigation to determine the factors leading to these outages. We know that fiber optic line cuts have been the culprit of some of these outages. We also know that accidents will happen, and that's why we must have redundancy built in to assure access to 911 services. As we wait for the completion of the investigation, the PSC has already identified one of the problems. As we switch over to next generation 911, not all telecommunications providers have installed the new Internet Protocol routing system, which is designed to increase redundancy. The older routers were the potential point of failure in some of the 911 outages. The complications created by these dual systems are contributing to the outages problem, and we need to get carriers off of the old legacy system. AM 2905 makes a few changes to the bill at the request of the telecommunications companies. In addition to a few clarifying tweaks, the amendment also adds a new subsection that specifies the parameters by which the Public Service Commission may mediate should the originating service providers and the next generation 911 contractor not come to an agreement on how to meet requirements related to the migration to next generation 911. There are issues related to routing that the providers need to resolve among themselves, but we need a safeguard in place to ensure that this happens in a way that allows requirements to be met by the January 2026 deadline. The PSC and the service providers are all on board with these parameters. With that, I ask for your green vote on AM 2905, Committee Amendment 2780 in the underlying bill. Thank you, Mr. Speaker.
Mr. Clerk, for announcement.
Thank you, Mr. President. Notice that the Revenue Committee will be holding an executive session in room 2022 at 4:00 p.m. Revenue Committee exec session room 2022 at 4:00 p.m. That's all I have this time, Mr. President.
See no one in the queue. Senator Frederickson, you're welcome to close on 2905. Senator Frederickson waives close. Colleagues, the question before the body is the adoption of AM 2905. All those in favor, vote aye. All those opposed, vote nay. Mr. Clerk, please record.
38 ayes, no nays on adoption of the amendment, Mr. President. Yes, sir.
Mr. Clerk, for an amendment. The amendment is adopted. Next amendment.
Mr. President, Senator DeBoer would move to amend with AM 2956.
Senator DeBoer, you're welcome to open on 2956.
Thank you, Mr. President. Good afternoon, colleagues. I'm excited to talk to you today about LB 1031, but specifically I'll talk about my piece, which is LB 1256, sections 12 and 13 of Amendment 2780, and modified by AM 2956, which is on the board now. I'll talk about that amendment in a minute, but first I want to talk for a second about the underlying LB 1256, which I am adding in, or which was added in by the committee amendment. Last year, Nebraska experienced multiple 911 outages, the first of which occurred in August. By December, we were informed that there had not yet been a hearing to investigate these outages, though they had at that point scheduled them for the end of the month. I know the Public Service Commission has their process for these hearings, but the public deserves information more quickly, I thought. Anytime there is an outage, the public deserves to know why an outage occurred, that there are plans in place to avoid an outage from occurring again, and anyone responsible is being held accountable. These are essential services we're talking about here, folks, with 911. So I introduced LB 1256 to speed up the process. Let's get answers. Let's be sure the public knows we're protecting our 911 services. So LB 1256 achieves this by doing two things. First, when a service provider experiences a 911 service outage, they must file a series of reports with the Federal Communications Commission. By LB 1256 says that anytime a report has to be filed with the FCC, the same report needs to be sent to the PSC. So we're sharing our information with the state as well as with the feds. The second piece of the bill is to be sure that there is a public hearing on any outage within 90 days upon receipt of the report mentioned previously. The PSC can hold subsequent hearings as they deem necessary to investigate that outage, but they have to at least hold one within 90 days. With the receipt of the report and the mandated timeline for a hearing, it is my belief that we will have answers quicker than the status quo. AM 2956 is a compromise amendment between the CTIA, the National Organization for Wireless Providers, and myself. Wireless telecommunications services are exempt from PSC authority pursuant to Nebraska Revised Statute 86-124. And though there is an exemption in subsection 6 of section 13 of this bill, the language included in AM 2956 will ensure that they are in fact completely exempt. With this change, CTIA is neutral on the bill. The second change included in the amendment is to ensure that the outage report filed is indeed the outage report for 911 services and not other potential service outages. I am fine with the language in this amendment. Basically, colleagues, the wireless providers wanted to make doubly, triply, quadruply sure that they were exempted from the provisions of my bill, and I'm happy to do so. So we clarified that for them. So thank you, colleagues, and I would encourage your green vote on AM 2956, AM 2780, and LB 1031. Thank you, Mr. President.
Seeing no one in the queue, Senator DeBoer, you're welcome to close. Senator DeBoer waives close. Colleagues, the question before the body is the adoption of AM 2956. All those in favor vote aye. All those opposed vote nay. Has everyone voted? Mr. Clerk, please record.
36 ayes, no nays in adoption of the amendment, Mr. President. Amendments adopted.
Mr. Clerk, for an amendment? The amendment is adopted.
Mr. President, next amendment, Senator Bostelman would move to amend with AM 2893.
Senator Bostelman, you're welcome to open.
Thank you, Mr. Speaker. AM 2893 is a technical amendment from bill drafters. Since LB 61 was recently passed on final reading, AM 2893 would harmonize the dark fiber language in LB 1031 with the language in LB 61. Specifically, both LB 61 and LB 1031 are amending the same dark fiber statutes, which is 86-577. We need to mirror the language in 1031 with the language in LB 61. So AM 2893 simply replaces the language in 1031 of 85-577, which is section 6, for the LB 61 language of 86-577 with section 7. I asked for your green vote on AM 2893 and LB 1031 and its advancements to select file and AM 2780. Thank you.
See no one in the queue. Senator Bostelman, you're welcome to close on 2893. Senator Bostelman waives close. The question before the body is the adoption of AM 2893. All those in favor vote aye. All those opposed vote nay. Has everyone voted? Mr. Clerk, please record.
35 ayes, no nays in adoption of the amendment, Mr. President.
AM 2893 is adopted. Mr. Clerk?
I have nothing further at this time, Mr. President.
Senator Mosier, you're welcome to close on AM 2780. Senator Mosier waives close. The question before the body is the adoption of AM 2780. All those in favor vote aye. All those opposed vote nay. Has everyone voted? Mr. Clerk, please record.
36 ayes, no nays, Mr. President, adoption of the committee amendment.
AM 2780 is adopted. Senator Bostelman, you're welcome to close on LB 1031. Senator Bostelman waives close. The question before the body is advancement of LB 1031 to ENR initial. All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
38 ayes, no nays on advancement of the bill, Mr. President.
LB 1031 advances. Mr. Clerk, for items.
Thank you, Mr. President. Amendments to be printed, Senator Wayne, Hunt to LB 137. Additionally, motion to be printed from Senator Conrad to LB 1393. And notice committee hearing from the Business and Labor Committee. That's all I have this time, Mr. President.
Thank you, Mr. Clerk. Next item, please.
Mr. President, next bill, Legislative Bill 441, introduced by Senator Albright. This is a bill for an act relating to crimes and offenses to amend Section 28815, change provision relating to offenses for offenses involving obscene materials to harmonize provisions and repeal the original section. Bill was introduced on January 13, 2023, referred to the Judiciary Committee. That committee reports the bill to general file with committee amendments.
Senator Albright, you're welcome to open on 441.
Thank you, Mr. President. Well, good afternoon, colleagues. This is my priority bill for 2024, last bill that I'll be prioritizing for the 8-year session. And it was a bill that I had introduced back in 2021, I believe it was. So let me just explain. And when you actually look at the bill, it's very, very simple. And it's just 3 pages, actually 1 full page. And we'll talk about it. So LB 441 is a simple bill. It closes the unintended loophole in the Nebraska obscenity law. LB 441 would revise state statute 28-815 primarily as follows. Quote, it shall be a defense to a prosecution under section 28-813 that number 1, such person's activity consists of teaching in regularly established and recognized post-secondary education institutions or galleries or libraries of such institutions. Currently, it is against the law for anyone in Nebraska to present materials considered criminally obscene or harmful to minors, except in K-12 schools and libraries. And I repeat, except in K-12 schools and libraries. In Nebraska elementary schools through high schools and school libraries, it is currently lawful to present criminal obscenity to any age school child. It makes no sense that schools and libraries of all places should be given a pass to expose children to material that the law already would recognize as criminally obscene to children. The drafters of the original legislation never intended this loophole to exist. At the hearing on the bill, this bill back in 2021, I presented the legislative history for the original statute. A former state senator, Pat Vendetti, testified that the legislators in 1977 intended the exact opposite. The 1977 obscenity law was particularly and expressly intended to protect school children from obscenity. The exception from prosecution was intended for post-secondary education institutions only, not for K-12 schools. LB 441 corrects this drafting error in the original bill. LB 441 just says the same obscenity standard applies to everyone in Nebraska, no exceptions. So who in their right mind would argue that a criminal obscenity should be presented to our school children at school? LB 441 does not change a thing about the definition of obscenity as applied under the Nebraska law. Whatever would have been considered obscene or harmful to children previously or not obscene remains the same. Nebraska statutes already define what is criminally obscene, unlawful to present to anyone, adults or children, and what additional sexually explicit materials are harmful to minors, a more strict standard to protect children. These Nebraska laws have not changed in 47 years since 1977. LB 441 would simply make Nebraska's obscenity statute applicable to K through 12 schools and their libraries, just as these obscenity statutes are applied everywhere else in Nebraska. I'd ask for your green vote on LB 441. Thank you, Mr. President.
Senator Wayne, you're welcome to open on the committee amendment.
Thank you, Mr. President. AM 2789 was heard on the, or LB 441 was heard on Judiciary Community March 24th, 2024, or 3, sorry. And the committee voted 5-0 to amend the bill with AM 2789 and advance the bill with 3 members present not voting, stating the intention of LB 441 is to close the so-called loophole in Nebraska obscenity statute, as Senator Albright just said. The claim is that the current law allows persons to present obscene material to children in schools and in libraries. However, LB 441 would amend Section 2815, which is the defense to prosecution under Section 28813. Section 28813 is the general obscenity statute for presenting obscene material to adults, not minor kids. Presenting obscene material to minors is criminalized as 28808, 28808, and 28809. The defense to such prosecution is under the sections contained in 28810. 28810 is somewhat confusing to read. This obscenity statutes that Senator Albright has already alleged are old when they were passed, and so it is somewhat confusing. It incorporates defenses of 28-815 and also requires the minor's parent or guardian to be present. To be clear, in the school or in the library, being in a school or a library is not a defense under Nebraska law to presenting obscene materials to minors when the minor parent or guardian is not present. The committee voted to adopt AM 2789 to clarify sections 28-810. There is another amendment that'll be coming out, which I'll talk about on the amendment from Senator Albright. So I will leave that section to the next section where I talk about, where I get on and talk about Senator Albright's amendment. With that, I would ask you to vote green on 2789. Thank you.
Mr. Clerk, for a motion.
Mr. President, priority motion, Senator Conrad would move to bracket the bill until April 18th, 2024.
Senator Conrad, you are welcome to open on your motion.
Thank you so much, Mr. President. Good afternoon, colleagues. I had a chance to visit briefly with Senator Albright about this measure a few times during the course of the session, and then I think, again, briefly this afternoon, just a few moments ago. For those watching at home, I think that we were all planning to have 2 additional hours of debate on 137, and so our agenda is a bit accelerated this afternoon, and everybody's doing a great job to make the appropriate adjustments, but perhaps it didn't allow for as much of an opportunity to visit with each other about some of the bills later down as we normally would do. But I want to start off and let folks know that I haven't decided yet whether or not I want to take the motion to a vote, but I do think that there most likely will be a filibuster at some point on this measure, whether it's on general file or select file, and we'll just kind of have to see how the debate shakes out. And here's why. Let me preface my remarks by noting that, and I've said this to Senator Albright, and I mean it, and I want to reaffirm for the record, no one can doubt the authenticity and sincerity of her commitment to protecting kids. She has been candid and consistent in regards to her legislative career on a host of different fronts and really making that a primary focus of her legislative work. And I know from her hard work that we waged together on the Education Committee to watching her bring forward other issues that are important to her agenda and to her district, that she thinks about those, about her kids and about her grandkids and Nebraska's kids very deeply and very sincerely. And we've had a lot of conversations about how challenging it is as a parent and grandparent to manage a lot of the harmful content that is in the world impacting our kids. And I think any parent and grandparent can definitely relate to some of those concerns. I know that I sure can as a mom with two little ones who is constantly trying to wage and then lose the battle with screen time and whatever else might be out there, and setting the appropriate parameters to make sure that we can protect our kids online. But in addition to being a mom and very active and familiar with how our school library works here at Riley Elementary in North Lincoln, I'm also the daughter of a longtime, now retired elementary school teacher. So I spent a lot of time in our public schools growing up, watching my mom work on the evenings and weekends. And as you all well know, I'm a civil rights attorney as well. So I've dedicated my career to fighting for fundamental rights and freedoms, including First Amendment rights to free expression and academic freedom as well. And I think that there are a lot of implications in LB 441 for academic freedom and for free expression and for the right that all school children have to learn. And I do not doubt that Senator Albright is sincere in trying to protect kids from harmful content. I completely and totally understand that. And I don't think that there's any disagreement amongst any of the stakeholders or members in this body that we want to do right by Nebraska kids. I do think once we delve into the minutia and details of this bill, that I think hopefully the majority of the body will see that this is perhaps not the right remedy or the right route to pursue in order to keep our kids safe at school. And I'll tell you, I do have concerns of being the parent of young children about what's happening in our world, how that implicates their time in the school building. But I can tell you wholeheartedly, I'm not scared about what my kids are checking out in the library. I'm not. I'm grateful that we have caring librarians in our schools all across Nebraska. It's exciting for me to be able to read with my children and talk about what they're bringing home from school. And I have yet to see any objectionable materials come home in that regard. And I think there are just a lot of really challenging issues in this legislation as proposed, advanced, and amended that could have serious chilling effects and impacts on teachers, on librarians, and on students and their ability to learn as well. And when this measure was advanced, I heard a outpouring of concern from teachers and librarians in my district who said, why on earth, with all the troubles in the world, is the Nebraska Legislature trying to weaponize criminal law in regards to my ability to help kids read and get kids excited about literacy and do research? And even knowing that it's unlikely that any of the measures that are in our school libraries are going to be considered obscene, because as I understand it, colleagues, most schools have a pretty clear process in place for how content is curated and selected and utilized. And if parents or other community members have concerns about those books, there's a process that they can go through to address that. But we should not weaponize the criminal law against librarians in Nebraska. That's just where I come down on it. Just by the threat of potential prosecution, that's going to have a chilling impact on our ability to recruit and retain loving, caring, talented librarians in Nebraska, loving, caring, talented teachers in Nebraska. And this bill itself does little to remove the content that Senator Albright and others are concerned about, but really puts a target on the back of librarians who, let me be clear, we talked about this in the Education Committee this interim. Librarians are not pornographers. Librarians don't want to hurt kids. Librarians are excited to help kids learn how to read. They're excited to help kids learn how to research. They are caring, and they are there as a trusted member of our school communities to do their important work. I know a lot of the librarians that I was lucky enough to know growing up really sparked my love of learning and really opened doorways to so many new ideas for me as a student that I'm forever grateful for. And this is part of, I think, and it's not Senator Albright's concern necessarily in regards to why she brought this bill, but friends, this is a part of a broader dialogue. If we have challenges in our schools, we need to turn down the temperature with these manufactured culture war issues. We need to be clear-eyed and thoughtful about providing resources and a constructive political dialogue to ensure that our public schools remain strong. And where they need improvement, they get improvement. But that includes providing resources and a thoughtful political climate so that our hardworking professionals in the classrooms and in the libraries can do their job without political interference. And what's right for some families may not be right for my family.
1 minute.
But there's a process in place, thank you, Mr. President, for me as a parent to direct that already. And by weaponizing the criminal law and inserting it into our school libraries needlessly, it sends the wrong message. It has a chilling effect. And it definitely has sparked more than concern, but significant worry from the librarians in my district and across the state that I've heard from. I'm asking you at this point to keep an open mind on the bracket motion. I filed it to help structure the debate. I appreciate and understand Senator Albright's sincerity in trying to keep kids safe in Nebraska. I want the same thing. We just have, I think, perhaps a different idea about the best remedy to do just that. Thank you, Mr. President.
Senator Blood, you are recognized to speak.
Thank you, Mr. President. Fellow senators, friends all, I stand in support of the bracket motion at this time. I had hopes that the bill would be better with the judiciary amendment, but I see that another amendment has been filed by Senator Albright that I believe makes it more convoluted. And so I have some grave concerns, and I hope we really talk things out today on the mic. Debate is healthy and beneficial to those who actually stay in the chambers and listen. I know that a lot of people are gone right now, but I'm hoping those that are here are actually listening to today's debate. With that, I would ask that Senator Albright please yield to some questions.
Senator Albright, will you yield?
Yes. Thank you, Senator Albright. Senator Albright, I'm trying to get my head wrapped around where this came from. So I have just some general questions I'm hoping you can help me with. So can you tell me if this bill relates to a particular case here in Nebraska?
A what case?
A particular case here in Nebraska?
No.
So has there ever been a librarian or a teacher, to your knowledge, here in our state that's been charged with providing obscene materials to children?
Well, I sit on education, and we had a bill this year, but this bill was brought well before this year, about a lot of the teachers and or librarians, generally speaking, in the setting of a school, their they have a jury of their peers, if you will, that they look at, because there's not an obscenity law out there. So there wouldn't be any reason to do anything more than discuss it with them, tell them not to do it again, and move on.
There are obscenity laws. If indeed they had obscenity,
Right,
they
but
could
not in
be
K through
charged.
12.
I'm sorry, but not what?
Not in the K through 12 institution.
No, in any obscenity or pornography is covered under state statute, regardless of whether it's in school or on the streets. Is that not true?
No, it's not. And that's why we should be, I'd be happy to discuss some of the statutes so that we will be aware of the fact that unless this bill gets changed to K through 12, they will not have any reason to take it any further than just talking about it.
All right. I think you and I are going to differ on that one, but I appreciate your opinion. So the way I read the original bill, and I referred to the state statute, and I thought maybe the judiciary amendment fixed it, but then again, I see a secondary amendment, so I'm not sure it's fixed. It really referred to affirmative defenses, the way state statute reads, and that means a person can't even be charged with a crime. So if it means a person can be charged, but has to present evidence and prove by preponderance, I'm not an attorney, but I'm going by statute, that they committed the crime, but that affirmative defense allows them to be found not guilty, then what's the purpose of the bill?
Well, I can certainly elaborate on what my amendment would do versus what the committee had agreed to.
So your original bill, to me, when I go back to state statute, refers to the affirmative defense. And so that's my concern, is I'm concerned that the bill doesn't do what you want it to do, Senator Albright, because after a defendant proves the affirmative defense, the state has to disprove the affirmative defense beyond a reasonable doubt. So is your intent to not charge people, or is your intent to hold people accountable and charge people?
Well, it does both. I mean, if they are charged with it and they're held accountable, they are up to a misdemeanor and up to a year in jail. So if they are found that they've done something that egregious, yes, they will have to prove it to a court of law.
Since this is criminal, how many county attorneys, thank you, Mr. President, how many county attorneys, defense attorneys, the bar, how many were engaged on this hearing? Did they come and testify in favor or against?
I don't believe, I do have in my notes, I can get back to you exactly who testified and let you know. I couldn't tell you off the top of my head.
Thank you, Senator Albright. I'll buzz in later and ask some more questions.
Thank you.
Senator Conrad, you are recognized to speak.
Thank you, Mr. President, and again, good afternoon, colleagues. I want to just put a few kind of general ideas into the record and ensure that people have a good understanding about how this might work in a practical sense. So if you're a teacher or a school librarian who would be charged under our obscenity laws for doing your job because a community member's upset or a parent's upset, and perhaps there's a rogue prosecutor that decides to bring a case forward, even though it would be a misdemeanor, let me just be clear about a couple of things. Getting hauled into court, having charges filed will absolutely disrupt your life. Whether you are ultimately found innocent or not. I think it's pretty well established that most teachers and most librarians aren't in it for the money. They don't make a lot. And hiring an attorney, because they probably make a little bit too much to qualify for a public defender, but hiring an attorney for a misdemeanor case like this, generally speaking, you're probably talking about, if you go to trial, over $5,000 that you're going to have to outlay to try and fight for your innocence and protect your rights in court. Even if you are ultimately found innocent, if one of these cases would move through because you provided materials that have been carefully curated by an existing process that have literary and educational and artistic value and benefit. Let's say you're drug into court, you have to protect yourself, you're ultimately found innocent, the system worked. That's still going to be out there, and you may or may not have additional implications for your professional teaching license as well, which is a whole nother round of lawyers and more headache and heartache and a mar on your record and your ability to do your job. So it's no small thing to say, well, oh, it's just a misdemeanor, and oh, they just lose an affirmative defense and they can sort it out later in court. It's actually a very serious and a very disruptive thing when you have to go through a case like that, and it has implications and bearings on your professional licensure as well. Not to mention a lot of headache and heartache when it comes to community relations as well, that needs to be taken into account. So the other part that I wanted to talk about a little bit was what might be right for me and my family and my kids in terms of curriculum or what they're reading may not be right for every kid or every family or every parent that's out there. And that's okay, because the existing law without these changes actually strikes the right balance for parental rights and academic freedom and expression. So under Nebraska law, generally speaking, because we only have such a short period of time on the mic, as a parent, if I find something objectionable, I can opt my kid out of that curriculum basically at any time for any reason, period. So if it's not right for me and my family, the kids don't have to learn that part.
1 minute.
Thank you, Mr. President. If the book's not right for me and my family, you don't have to read it, right? Let's dial it back here a minute to acknowledge and understand the fact that if a book is in a library, it's not mandatory that you read it. It's a self-selection. So if a kid brings home something that is objectionable, I think there's a process in place to talk about whether or not that should be on library shelves. But we shouldn't weaponize the criminal law against teachers and librarians in order to fight those culture war battles and book banning battles that have sparked up across Nebraska and across our country, unfortunately. There's a resurgence in those efforts to deny information to students. Thank you, Mr. President.
Senator Dungan, you are recognized.
Thank you, Mr. President, and good almost evening, colleagues. I do rise today, I think, in support of the bracket motion overall, and generally, I think, respectfully opposed to LB 441. I don't want to rehash a lot of what's already been said, but I want to start by saying I also echo the sentiment that I think this comes from a genuine place of wanting to protect our kids and wanting to protect our schools and ensure that we're, making sure there's not gratuitous obscenity being distributed to kids. What I think is important to note at the outset of this conversation is that I do not believe that is currently happening, and I do not believe that our libraries or our teachers are distributing obscenity, or to put it more plainly, pornography to kids in libraries. I simply just don't think that's happening. And I have paid close attention to this debate and this discussion that's been going on in the broader zeitgeist of our state here, as we've had state school board meetings and presentations about this. And based on the evidence that I've seen, and based on the evidence that's been presented by proponents of pieces of legislation such as this, I simply am not convinced that our local public school or city libraries are distributing just blatantly obscene material that doesn't have with it any literary or cultural value. And so I think that that's an important thing to note and to say firmly and plainly, that I do not share the concerns of some others that is currently happening. Now, that being said, we have statutes in place, 28-808, 28-813, that specifically speak to the distribution of obscene materials to minors, or the distribution of those materials in our city libraries or in our schools. The current statutes that we have then allow under 28.815 to create this affirmative defense. It's a little bit confusing what that actual affirmative defense is, given the way the statute is written, and I anticipate we're going to be talking about that quite a bit more as we go on through this debate. But I want to start by going back to a little bit of what Senator Blood was kind of highlighting with regards to how this currently works. So there is a confusion or a conflation, a mix-up, if you will, between what an affirmative defense is and what an immunity is. I've seen presentations given to the State School Board of Education that seems to imply that there is currently an immunity or an inability to charge somebody with obscenity in schools. And even in the intro to today's bill, I think we heard that this was a loophole, that currently there's the ability to distribute pornography or obscene material in schools because this immunity exists. That is not true. And I think it is a misunderstanding of how this process works. So currently, if there were an allegation that an obscene material that was in violation of the Nebraska laws was being distributed, let's say in a school library, or a city library, that allegation could be made to the local law enforcement. The local law enforcement could then go, or would then go, investigate that allegation. At that point in time, if based on their analysis or their investigation, they find probable cause that in fact the law has been violated, they could cite the individual who is distributing that material. That citation, that ticket, essentially then goes to the county attorney's office. And it's up to the county attorney in whatever local jurisdiction that would be to analyze all the information given to them, the probable cause affidavit, the police reports, what have you, and then they would ultimately make the decision as to whether or not that individual should be charged. They are currently able to charge that if they wanted to, and if somebody was in fact violating the law. At that point in time, the court process would take place. If ultimately this goes to a trial, it is the state's job first to prove beyond a reasonable doubt that the law has been violated. The current 808, 813, whatever you may have, it's the state's job to prove that that's been violated. Then, if that teacher or librarian or whomever wants to assert, thank you, Mr. President, the affirmative defense that they are protected by the law, they can then present evidence and have the burden to present evidence, I think by a preponderance of the evidence, that they're protected by that law. The burden then shifts back to the state to say, no, 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 actually you're wrong. The evidence does not support your affirmative defense. And if ultimately at the end of the day, the jury finds that the facts do not support that affirmative defense, that person can be convicted. So the only people currently protected by this are people who are asserting whatever this affirmative defense may be, which is I am working within my confines as a teacher or librarian or whomever else is covered by 815. So we need to be very clear. There is not currently an immunity against prosecution. It is covered by the law. This simply removes protections for teachers and librarians acting within their purview and their duty in their jobs. Thank you, Mr. President.
Senator Brandt, you are recognized.
Thank you, Mr. President. And I would sincerely like to thank Senator Albright for bringing this bill and the Judiciary Committee for advancing the bill. I agree with the intent of keeping obscenity from young children. And I spoke a little bit with Senator Albright, and I'll try and keep an open mind on this. But I guess I feel this bill does not change the definition of obscenity. I feel the way it's written currently, it's overly broad and confusing, and it only punishes librarians. I went through this and read this several times. Most of these librarians are expert with 4-year degrees or more in the library sciences. And then you go to our public schools and our public school boards, at least the ones in my district, I've got a lot of faith in these public school boards and the librarians in our schools. I haven't had one complaint in my 14 school districts or in my cities, and I think they do a great job. In our schools, what we see a lot on these parent concerns is we quite often have a very vocal minority telling the majority what to do. And I think on these books that kind of translates to that. Last week I talked to Senator Bozen, and we spent about 15 minutes trying to work through this bill and so we can understand the penalties on the librarians, and I left probably just as confused after that as what I was before. I don't know if these are civil penalties or criminal penalties. She was unaware of any prosecutions, and she was a prosecutor. And I guess Senator Albright, and I've said this, some of the questions that I would need addressed. Does this also apply to private schools and homeschoolers? What about schools that don't have a librarian? We have these really small schools, and I know you've got some in your district, where maybe a teacher is a librarian or a volunteer is a librarian. And I also feel this is an issue of the State Board of Education. What I've seen for the 6 years that I've been here in all facets of legislation is somebody gets beat or on a county level, and then they come to the state and they want us to pass legislation. And I really think this is something that the State Board of Ed could work on. I kind of compare this bill to going to see a doctor for a broken arm and then penalizing the doctor for your own broken arm, if that made any sense. But you know, people that know me know I love libraries. I read a wide variety of literature, and a lot of it is because of the time I spent growing up in the Beatrice Public Library, the Tri-County Public Schools Library, the UNL libraries, and many others in my younger years. And I'm concerned about the unintended consequences. So in this very building, when you walk out here, and I got this brochure at the end of the hallway, and it describes the Great Hall. And when you go from the rotunda to the vestibule, that is the Great Hall. And on the floor of the Great Hall, we have 3 mosaics. And it's the spirit of the earth. And the first one's called the spirit of the soil. Second one is spirit of vegetation. And the third one is the spirit of animal life. And for over 90 years, school children, primarily, we will see 40,000 fourth graders annually will walk over and view these naked artworks. I mean, are we going to lay carpet over the rotunda and Great Hall to protect our fragile sensibilities? I would hope not. You know, I ask you the next time you're out here to look at the mosaics on the floor. And, you know, that's artwork. And we all know that's artwork.
One
but
minute.
That's the problem with these obscenity laws. You know, and what about our high school literature or college prep English classes? They study the classics. And I mean, you can nitpick Shakespeare, you can take the Bible and go to the Song of Solomon. I mean, there are a lot of instances out here where things can get attacked. So anyway, I'm concerned about the unintended consequences going forward. And currently as written, I'm opposed to the bill, but I will listen, Senator Albright, and see if this can be changed to make it acceptable. Thank you, Mr. President.
Senator Merman, you're recognized to speak.
Thank you, Mr. Speaker. I rise today in support of Senator Albright's LB 441. As Senator Albright explained, this bill does not create some set of new obscenity laws, but goes back to our existing ones and simply removes one loophole exemption that currently exists. Senator Albright has already done a good job explaining the need for the bill, so I'd like to spend my time addressing 2 criticisms of the bill. The first common criticism is that it is some kind of attack on First Amendment. Opponents have made various claims that this prohibits protected speech, or this chills speech, or this is somehow unconstitutional. These claims all fall flat. The reality is that obscenity is not legally or constitutionally protected speech. But don't take my word for it. Allow me to read a quote directly from the U.S. Department of Justice's website, which reads, "Obscenity is not protected under First Amendment rights to free speech, and violations of federal obscenity laws are criminal offenses." So while I appreciate that and will listen to the opinions given by the opponents of this bill, I'm ultimately going to side with the Department of Justice's opinion as the more credible source. The DOJ's website goes on to say, "It is important to note that the standard for what is harmful to minors may be different than the standard for adults, and offenders convicted of obscenity crimes involving minors face harsher penalties than if the crimes involved only adults." So not only are obscenity laws not unconstitutional, but there is even a stronger legal basis for them when it comes to sharing obscene content with children. The second common criticism I have heard is that this bill is unnecessary. Some have made arguments that claimed there is no obscene content within classrooms or libraries. While this statement is untrue, and we can prove it is untrue simply by reading the transcript where parent after parent read obscene content into the record, this claim is not especially important. Even if it were true and there were seriously 0 obscene books, not a single one within our schools, then I ask, what is the harm? If there's not a single pornographic book in the libraries, then LB 441 has no effect. If there is no effect, there is no negative consequence to our green vote today. Now the opponents will go on to say the negative consequence is teachers and librarians facing legal consequences. But if teachers are at risk of facing consequences, then this is an admission that there is indeed obscene content in our schools. So either could be true. Either there is no obscene content currently in our schools, or teachers could face consequences. But both results cannot be true. With that, I'll be closing, thanking Senator Albright for her work on this bill and her constant mission to protect Nebraska's kids. And I yield my time back to the chair.
Senator John Kavanaugh, you're recognized.
Thank you, Mr. President. Well, colleagues, I rise in support of the bracket motion. And I know Senator Conrad said you put it up to structure debate, but I do think it is a sincere bracket motion because my first thought about Senator Albright's introduction was she said this was a simple bill and easy to understand. I've got some notes here, simple. And I echo the comments of my colleagues who have said they appreciate Senator Albright's sincere desire to protect children. And we do really have a privilege and a burden to ensure that children are raised in the best way possible and not exposed to certain things that they're not ready for. And the law already provides for that. And my issue with this bill at the moment is I've had conversations with dozens of people and have had a dozen different interpretations of what this bill does. There's a lot of people who don't think it will do anything. There's a lot of people who think it will do lots of things. And then there's a lot of people who echoed the comments of Senator Merman now that this bill will have a chilling effect. I know that's Senator Merman saying that's not what's going to happen, but I don't think you have to be overly creative to think of how increasing the threat of prosecution of teachers will have a chilling effect on teachers, even if the books they're thinking about putting in their classroom are not even close to obscene. I would also point out, Senator Merman, you pointed out to the record of the hearing on this bill. The folks who came and read those books, they read things that would be characterized as literature, books that have intrinsic artistic or political value, which are books that would not be characterized as obscenity. Obscenity is not that which you do not like, right? It has to be more than that. And I will read for everybody. So this is State v. Herald, which is the Nebraska Supreme Court case that defines obscenity using the standards set out in Miller versus California. Miller versus California is 413 U.S. And then let's see. Well, here we go. Herald is 256 Nebraska 829. So on page 837, First, a matter is not obscene under Nebraska law unless, taken as a whole, an average person applying contemporary community standards would find that work predominantly appeals to the prurient interests or a shameful or morbid interest in nudity, sex, or excretion. So, and then it goes on to say, even if it is that, second, even though a matter depicts hardcore sexual conduct, which appeals to the prurient interest, it is not obscene unless, taken as a whole, the work depicts or describes in a patently offensive way sexual conduct specifically set out in sections 28.807 to 28.829. So that refers to statute. And then third, even though the material appeals to the prurient interests and is patently offensive, it cannot be obscene constitutionally unless the work taken as a whole lacks serious literary, artistic, political, or scientific value. So there's all of these other aspects and definitions that are required to meet the obscenity standard. And so to go back to what Senator Dungan was talking about, the affirmative defense portion. And this is something that's really important to get the distinction between. Affirmative defense is not a loophole or a bar from prosecution. It is a defense that can only be asserted after someone has been charged. So you have to have already gotten past that definition. All of those, checked all those boxes and shown that somebody has distributed something that qualifies as obscene under those definitions. And then, and only then, when you're in court and the state has put on its case and demonstrated all of those elements, that then the defendant would be able to raise the affirmative defense. So, and the affirmative defense, and this is the part, I'll have to push my light probably to get back on, talk about the parts of this bill that I do not understand. And I would say evidence to the confusion is that 3 substantially similar amendments to the bill have been filed.
Time, Senator.
Oh, thank you, Mr. President.
Senator Reapy, you're recognized to speak.
Thank you, Mr. President. Well, I am concerned about any time that you talk about obscenities, it's obviously an emotional kind of an issue. And I do appreciate Senator Albright's interest and her integrity and her going after this. Most of the issues about seems to be around the legal precedents and the legal defense of this particular issue. I do have a couple of questions that I would like to see if Senator Albright would be willing to address.
Senator Albright, will you yield?
Yes.
Senator, thank you. Can you tell me what the position or policy for this obscenity is with the State Board of Education?
I don't believe that there's any policy. Last Friday, they had a robust debate, and it went 5-3, from my understanding, about a lot of the things that I believe it was Kirk Penner that brought the information to the State Board of Education.
Okay, thank you. I have a second one, if I may, Mr. President. Do you embrace the State Board of Education avoiding its responsibility from delegation of the leadership of this particular issue as it has with the sports and spaces? They seem to be non-existent or not into play and want to, in my opinion, delegate this up to the legislature. Can you respond to that, please?
Thank you, Senator Reapy. And here is just my thought process on this. When it comes to the State Board of Education, I do believe, I had a bill, as a matter of fact, in education, stating that it is our job on the floor of the legislature to make law. I don't believe that they have the ability to do that. So to me, I think the cart was before the horse that particular day, because in doing what we're going to do today with the obscenity law is giving them the authority to go do whatever they need to do within inside the schools. The Department of Education, in my eyes, if they see this being passed, I'm not making them do anything. We aren't making them do anything. This is already in law. We're just saying in K through 12, they really have to take a look at their practices, because if they are getting books in the library that are offensive and to a minor, it needs to go. And so that would be the schools to help those librarians get those books that are overstimulating to the children out of their libraries. And I just really appreciate that question, because I do believe that we who manage the funding of public schools, we must act on this so that they will understand that the State Board of Education can go after whatever angle they need to clean this up. Our children don't need these type of books in our libraries. There are so many other books that will stimulate them in ways that will make them the best person that they can be by the time they leave our school systems.
Okay, thank you, Senator Albright. My own concern or feeling is that the State Board of Education has failed in its leadership, and they choose to delegate up to make sure that the state is legally the one that will get sued and not to the State Board of Education. With that, Mr. President, if I have any additional time, I would yield that to Senator Duncan.
Okay.
Do I have any time?
Senator Duncan, 1 minute.
Thank you, Mr. President. I won't take too much time. I know we have other individuals in the queue, and I was talking with some people offline there, but I do appreciate the conversation with regards to the mechanisms and levers with which the State Board of Education already has in place. I do think that oftentimes issues like this should be left up to local control. Senator Conrad, I think early on alluded to the fact that most school boards, local school boards, have mechanisms with which they can bring complaints about books that are in libraries. And so I don't necessarily think this is an issue that we top down need to be having sort of larger government involved in, which is also a hesitation that I have as well. So thank you, Mr. President.
Senator Linehan, you're recognized to speak.
Thank you, Mr. President. I am not in support of the bracket motion, and I'm in full support of Senator Albright's efforts here. I would like to ask if Senator Duncan would yield for a question, please.
Senator Duncan, will you yield?
Yes.
I want to yield most of my time to Senator Albright, so I'm just trying to figure this out. Can you explain to me when you say affirmative defense?
Yeah, so I'll try to be as quick as possible. I'm not trying to take time unnecessarily. So it's not an immunity. So an affirmative defense means you can still be charged with something and then have it go to trial, and then the state has to prove beyond a reasonable doubt that you are guilty of all the elements of that crime. But if you want to assert an affirmative defense, the burden shifts over to you as the defendant to then introduce evidence in front of the jury saying, in this example, I'm a teacher, I'm acting within my purview as a teacher.
Okay, that's what I'm questioning. So a teacher can say that it's education, so somebody else, it might not be okay, but it's okay for a teacher to use this material.
I think, and this is, again, a genuine answer, I'm trying to understand what the actual elements of the affirmative defense would be based on the language in 815. I think it says, for example, such person.
What is the law right now?
That's what I'm trying to understand what that affirmative defense would be. I think they would have to say that their activity consists of teaching in regularly established and recognized educational institutions in the regular business of that profession.
But when you agree that educational institutions, there's just difference between K through 12, K through 8th grade, and the University of Nebraska or one of our state colleges, what you find in those libraries, they should be different, should they not?
I think that there are differences in those levels of education, yes.
Okay, thank you, Senator Duncan. I'll yield the rest of my time to Senator Albright.
Senator Albright, 3 minutes.
Thank you, Senator Linehan. And I really do appreciate this bracket motion. Certainly hope you don't vote for it, but this gives us all the ability to really sift through this and decide for ourselves, is this something that we need to be taking care of in our K through 12 educational services to our children? I mean, I want to go through, as I get on the mic, and I'll take as much time as anybody wants to give me, I want you to understand what these state statutes actually say. Because, you know, if you're a teacher and you're going to be charged with something, I do believe they pay, you know, the NSEA ends up helping the teachers if they have to go to court over something. I think that's one of the main programs that they have when they ask them for some money to protect them or to defend them. But again, so state statute 2808, this is all within this one sheet of paper. If you open up all of these different state statutes, they will explain what it means. And there are things like this that are happening in our schools. That's why people want to be able to opt out. Parents want to be able to opt out of programs that they don't believe that their child needs to take a look at just yet, or maybe it's something that they want to take care of at home, or they think it's too much information, or there's people within the institutions that, the K through 12, that present things to their children that they shouldn't be presenting to them. And I'd also like to get back to answering some of the questions and concerns that people do have, because it's something that, believe me, for the last 4 years I've been talking about it. I certainly didn't want this conversation just to go to libraries, because there are different things within a curriculum at school that can point to different things that maybe just don't need to be talked about in the schools.
1 minute.
Okay, thank you. So LB 28808 is the, within the bill, it's the obscene literature and material, the sale to minor, unlawful, and penalty. So number one, it shall be unlawful for a person knowingly to sell, deliver, distribute, display for sale, or provide to a minor, or knowingly to possess with intent to sell, deliver, distribute, display for sale, or provide to a minor. Well, they're not selling this stuff to the children in K through 12, but A says any picture, photograph, drawing, sculpture, motion picture film, or a similar visual representation or image of a person or a portion of the human body, or any replica article or device having the appearance of either male or female genitals with a predominantly, prudently, shamefully, or morbidly depicts nudity, sexual conduct, sexual excitement.
Time, Senator.
Thank you.
Senator Bosselman, you are recognized.
Thank you, Mr. Speaker. I stand opposed to the bracket motion. I do support LB 441. Senator Albright, and I want to thank her for bringing this bill. What we hear about the adult side of things, I want to focus just a couple minutes on the children. Isn't this what the bill is about? It's about children. It's about providing, those who are providing obscenity to children. And it's already illegal in the state of Nebraska. And Senator Albright said this simply closes a loophole. I think we all want to protect our children. Who feels that we would we refuse to protect children from criminal obscenity? By definition, that's harmful. Obscenity is harmful to children. This act only could be used in extreme instances of criminal obscenity production. That is because the legal standard is so hard to prove and few prosecutors would tackle it, except in really nasty, really bad cases. In close cases, Nebraska law already provides protection. Declaration judgment on obscenity from the court within 14 days. The bill should be seen as beneficial to our schools. They can demonstrate their good faith. Growing bodies of research show viewing obscenity has devastating long-term effects on young people. It's illegal for someone to ply your children and grandchildren with obscenity in a movie theater or the local convenience store. Why would we want to do that in schools? Obscenity is not education. Parents have the primary responsibility for the education of their children. When they send their children to school, they trust that school administrators, teachers, and staff will provide healthy learning environment. I want to focus on the children. It's the children we're looking to protect from obscene, harmful material that they may be exposed to. And I do support LB 441. I yield the rest of my time to Senator Albright.
Senator Albright, 2 minutes 50.
Thank you. Thank you, Senator Bosselman. I do want to continue on 28808. It basically says that any of that such abuse which is taken as a whole is harmful to minors, or B, any book, pamphlet, magazine, printed matter, however produced, or sound recording which contains any matter enumerated in subdivisions 1A of this section, excuse me, or afflicted and detailed verbal descriptions or narrative accounts of sexual excitement, sexual conduct, abuse, predominantly prurient, shameful, or morbid nature, and which taken as a whole is again harmful to minors. Any person who violates this section would be guilty of a Class 1 misdemeanor. Okay, then we go on to 28.810, the prosecution defense. It shall be a defense to a prosecution under sections 28-808 and 28-809 that a person shall, number one, have a reasonable cause to believe that the minor involved was 18 years of age or more, and that a reasonable cause is based on but not limited to the presentation by the minor exhibited to such person a draft card, license, driver's license, birth certificate, or other official or apparently official document supporting to establish such minor was 18 years of age or more. Number two, the minor was accompanied by his parent or guardian, and such person had reasonable cause to believe that the person accompanying the minor was the parent or guardian of that minor. Number three, such person had reasonable cause to believe that the person was the parent or guardian of the minor. And four, such person's activity falls within the defenses to a prosecution contained in section 28.815. And I'm going to continue to read these state statutes that are within this, that they can't go anywhere else in the state of Nebraska and let this happen to them. But we in our very K through 12 educational institutions are allowed to do this. And I don't think that it's something that they want these children to read. It's kind of like with the libraries anymore. It's out with the old books and in with the new. And who at the American Institution of Library Association, whatever it is that they call themselves, if they're able to ask or just put books like these in our schools. But again, the bill isn't just about libraries. It could be about anything so egregious that someone needs to go before.
Time, Senator.
Thank you.
Senator Blood, you are recognized.
Thank you, Mr. President. Fellow senators, friends all, I still stand in support of the bracket motion based on the many amendments that I'm now seeing dropped on this bill. And so at this time, I do not support LB 441. I do appreciate the definitions provided by Senator Merman, but really feel they have nothing to do with this debate right now. I think it's just more words in the air that are trying to make people scared of what they think might be going on in schools. But we've already heard Senator Albright say that she's not aware of anything as far as a librarian or teacher being charged with this. My concern is that we have curriculum in every single school. Curriculum and instruction, and they're made locally by individual school districts and classroom teachers. And so by pushing this bill forward, we're basically saying that we don't trust them, even though they are the professionals, and we suspect that they're doing something that's inappropriate. Now, you can say that that's not the purpose of this bill, but on the outside, that is how it looks. I still believe that current law would still stand in reference to obscene materials to a minor, but how do you charge them in a professional capacity? Well, apparently you charge them with a misdemeanor. But the thing that I always think is interesting about all of these bills that have come out the last 2 years, and we know that they come from other sources, is that we never talk about the racism in the books that it is inappropriate in the schools. Never do we talk about the racism in the books. We know there are so many books that we read in the 50s and 60s and 70s that were clearly racist. But I never hear you talk about that. All I hear you talk about is alleged obscenity. I think it's pretty obscene when there's so many books on the shelves that deal with racism. But of course, that's the ugly nature of the world. And our children have to learn about it no matter how ugly it is. So you'll never pass a bill about that. And I'm sure people will fight against it, and they should. But I think it needs to be noted that people that bring bills like this the last 2 years seem oblivious to that issue. And I just think it's important to get on record. So I keep listening to the lawyers, and I am not a lawyer, clearly. But what I don't understand is that it's my understanding, reading state statute over here, that an offense to a crime is not the same as an exception or an exemption. And I don't know if that's been made clear yet, because I've heard a lot of lawyers speak. So if I go up to my row mate, Senator Jacobson, and I punch him in the face because he says something that makes me angry, and that's not a threat, that's not an exception. We've had our moments. But let's be honest, if he comes at me with a baseball bat and I whack him first, I'm going to be charged, right? Because I'm trying to defend myself. And maybe I definitely will be accused. I'll probably be found guilty, but I still have the right to a defense. And I think that that's kind of the disconnect. There's lawyers standing over there listening to me. Is that right? Okay. Thank you. So those things are never going to happen. I keep my baseball bat in my car. But I don't think that this bill has a clear understanding of how the law works. And I think it creates more problems than it solves. We should all be concerned about the curriculum, the books that our children read. But why do we have political subdivisions if we don't trust that they will do their work that they're qualified to do? And if we are so worried about it, why are we not dealing with things like privacy directories when it comes to the internet? The things that we really know will help protect our children. But instead, we have these bizarre bills with both technology and now this library bill where we try and solve a problem that doesn't exist, but we don't look at it holistically to decide how we might fix it and make it better for everybody. I really hope that you start thinking, be more forward thinking about the big picture, moving in the future the next 2 years, because these bills are very small-minded in my opinion. And I don't mean any offense to Senator Albright, because I know her intentions are good, but this bill does not solve a problem that exists. Thank you, Mr. President.
Senator Conrad, you are recognized to speak, and this is your last opportunity before your close.
Time flies. Okay. Good afternoon, good evening, colleagues. Good evening, Nebraska. It's Senator Erdman and I were just having a lighthearted moment in regards to how quickly sometimes your 3 times on the mic can come up, even with a very, very full queue. So I just want to talk about a couple of pieces, and then, you know, maybe ask Senator Albright a few questions as well. The first piece being, even outside perhaps of this legislation, you can't erase the First Amendment, right? and so if a teacher or a librarian is engaged in protected First Amendment activity, and let's assume perhaps for the sake of this argument that Senator Albright and her supporters are successful in moving this forward and they remove this defense somehow or another. I guess if I was a defense attorney representing a teacher or a librarian who was hauled into court under some sort of concern in this regard, you know, maybe you'd file a motion to quash or something, because there is still the First Amendment. So I'm not exactly sure, again, if this remedy is going to do what Senator Albright is attempting to do. I think the other thing is that we need to be clear about, I guess, unfortunately, because we're having this debate, but if schools and teachers are passing out obscene or inappropriate content, that's a huge problem that we would all care about, right? That's not happening. You don't walk into Riley Elementary and get a Playboy or a Hustler or whatever it is, right? That is not happening. That is not what we're talking about. But you may get information that does touch upon themes such as race or class or gender or sexuality. And we know from the ongoing culture wars and the challenges that this is really very specifically directed to what I think is impermissible viewpoint discrimination. If it talks about LGBTQ issues, if it talks about sex, that's obscene. It's actually not. There may very well be well-established educational, literary, artistic value, even when those themes are discussed in an age-appropriate context. So again, remember, these books don't end up in the library willy-nilly. There's a process, a careful curation for how books are brought into school libraries that is carefully and closely tied to community standards, number one. So let's be clear about that. So I want to make sure that we don't divorce ourselves from that understanding. I'd also like to ask Senator Albright a few questions if she would yield.
Senator Albright, will you yield?
Yes.
Thank you, Senator. And we had a chance just to talk a little bit about this, but let's say I'm a brand new librarian and I am hired by Seward Elementary to help kids do reading and research. And so I show up at Seward. I haven't selected all of the books that are there. Thank you, Mr. President, when would the criminal liability be triggered? Do I have an obligation as a new librarian to look through the shelves? Do I have to wait until a questionable book is presented to me? Kind of what's your vision for how a librarian should operate if we remove legal protections for their work?
Again, this bill is about obscenity. So if there are books within that library, I would certainly hope that the local control that schools have today and have always asked us to allow them to have would have some type of a program to go through the books that are currently on the shelf. Because, I mean, a lot of times you read the back of the book, you think, yeah, that sounds pretty good.
Sure.
Flip through it a little bit. Yeah, this looks okay. But if your daughter or my granddaughter came home with one of the books, and I have all of the testimony that this poor transcriber
Time,
had.
Senator.
All right.
Thank you. Thank you, Mr. President. Thank you.
Senator Decay, you are recognized.
Thank you, Mr. President. I would yield my time to Senator Albright.
Senator Albright, 4 minute 50.
Thank you. Thank you so much, Senator Decay. I'm going to continue with the question that the Senator Conrad had for me. Again, when these children end up bringing a book like that home, you know, I'm certain that a parent would take the book back. I'm quite certain that my granddaughters would let their parents know about it, and grandsons, and just, here's the book. I'm in 4th grade. I took this off the shelf, and oops. I would imagine that the parent's going to go into the school and say, hey, you know, are these type of books on the shelf? You might want to consider taking them off. I think it's inappropriate. There have been books that have been taken off the shelf just in conversation like that. But if we are stocking our shelves, and I don't believe every book in the library is like that, but this book, this bill is about obscenity. If they are allowing for a child to have access to a book that is so awful. I mean, even for the adults in the room, when we had this hearing in judiciary, I mean, I call Fred Knapp and say, take this off the airways because you'll lose your FCC license. I mean, it was that bad. So we can talk all day about the libraries, but I can understand where some of you are concerned that somebody's going to go. If they get prosecuted because it was their intention to give that to them and overstimulate their brains and minds, then they'll probably end up, you know, being charged with something. But that's not the intent of this bill, is to find out when these libraries have these books, and some of them do. I mean, I have lots of information on where they're at, but I didn't want this to go toward all of the concerns that people have about teachers and librarians. But at the beginning of the school year. The teacher, I'll give you an example. One of our grandchildren had a 300-page book that the teacher was going to read to the class throughout the semester, and they were going to talk about it. So my daughter said, hey, can I take a look at the book? And certainly the teacher had no idea the depth of what was in that 300-page book. So together they marched to the superintendent's office and said, this isn't going to work. I cannot read this book. So they had to select something else. But in today's world, things have changed so much. Back in 1977, they didn't probably have to worry about these. They had the Jack and Jills and all the other type of books that we weren't concerned with. But today it is so much more than what we're talking about here, about a book in a library. I mean, it's on the laptops that we provide financially to take home and to share with the rest of the class on what they found. And believe me, it spreads like wildfire if that happens. But this is about obscenity and how we are going to control it in the state of Nebraska in K through 12 education. And it will change the model of how things are done, and it should, but it has to come from us. We are the ones that have to decide how firm do we want to be that this cannot affect the minds of our children in the K through 12 system. I mean, there's a little book out there that the little fourth grade and under can check out. And
1 minute.
I'm telling you, it's in my office. I'm sure I'm glad to let you take a look, but it is not appropriate in any way. It's perfectly normal, I believe is the name of the book. Google it, take a look. But every single page that you turn should never be in the hands of a child. Until they're ready, and you know what? These children are not ours because they're in our institution. These children are for the parents to be able to protect and decide what they hear, what they see as they progress in K through 12. But again, it's inside all the statutes will help the courts decide whether this is egregious enough or not to prosecute somebody. And if you have that, hanging over your head, you're going to think twice about what we're doing. I mean, we're
Time, Senator.
Thank you.
Senator Duncan, you're recognized.
Thank you, Mr. President. Colleagues, I still do rise in favor of the bracket motion, and I know we're probably getting close to dinner time, so we'll probably take a quick break before we continue this conversation. But I think we're having a legitimately good talk about what this bill does, what it doesn't do, and what we're seeking to actually prohibit. So I was just talking over here into the balcony with somebody about, I think, a disconnect that's going on here between the proponents and the opponents of this bill, and I think we're actually having a good debate about it. In my mind, colleagues, one of two things are true. Either there is a belief that actual pornography, and I'm talking like Penthouse, Playboy, those kind of things, are being handed out in schools and given to people in libraries, or there's a belief that the material that is contained in those libraries that allegedly contains literary and artistic and historical value also contains within it material that is deemed by some to be obscene. And I think that when we're talking about those two things, it's just important to situate what it is we're actually saying should not be provided to students. And I think obviously if anybody's handing out the former of the two, the blatantly obscene material, and just giving it to students in libraries, then that is a problem. And I think there's a legitimate conversation to have about that. But when we start to parse apart what is and what is not obscene based on what is bothersome, or based on what might be racy, or based on what might be risque, but it still contains in it that literary and historical and artistic value, we need to have a different conversation. And of course, there's always a discussion about appropriateness, and there's always discussions about levels. What is appropriate for an elementary school library may not be appropriate for a middle school library, may not be appropriate for a high school library. Those are different things that can be considered and taken into account and should be taken into account, but they are currently done by school boards, by librarians, and by people in public city libraries who understand what material is available. Colleagues, I know when I was in middle school or high school, I would go to the school library often. I spent a lot of time there, and I would check out books, or I would also just sit and read. And one of those in particular that just popped into my brain as we were having this conversation and talking about other topics that could be upsetting, like racism, I was remembered of a graphic novel called Mouse that talks about the Holocaust. And it's an incredible story that I would encourage everybody here to go read. But that's a book that has been banned in multiple libraries, that has been prevented from kids being able to read it. And it was one of my first experiences having an emotional understanding early in life of some of the trauma and the systemic oppression that went into a certain period of time. It was uncomfortable. There are certainly parts of it that were not fun to read. There are certainly parts of it that would be upsetting to some kids. But simply because it was bothersome, or simply because parts of it might be quote unquote risque or racy, I don't believe it rises to a level of needing to be banned, or that somebody should be charged for providing that. Now, I know we tend to be discussing a little bit more sexual content when we're having these discussions of these kind of obscene materials, and that is certainly what a lot of the case law surrounds. But I wanted to point out that what is important historically and contextually can be bothersome. And I think when we start to look at other historical novels that have great literary value, it's helpful in understanding this. You can Google lists of banned books, and you can find any number of things that I think many would argue do have historical value. One of the most banned books of all time is Ulysses by James Joyce. And that contains in it certain scenes that were shocking and that have led ultimately to, I think, certain bannings and trials. Obviously, another one that people talk about a lot is Lady Chatterley's Lover. Another one is Madame Bovary. These are pieces of literature that, while somewhat uncomfortable, are not without or devoid cultural purpose. And I think that that's very important for us to keep in mind. Beyond that, I also want to highlight once again, and I'll punch in and I'll get a little bit more into the legal aspects of this.
1 minute.
Thank you, Mr. President. In the event that somebody is distributing obscene material to students and doing so in a way that does not contain any literary value or is outside of their purview as a teacher, they can be charged. And in the event that that goes through the process and they assert this affirmative defense and are unsuccessful, they would ultimately be convicted if a jury of their peers deems them to be guilty of the underlying crime. And so the system as it currently operates works. I certainly have not heard of a mass amount of cases, but there is a system in place that currently operates. And so I just want to make sure we keep that highlighted when we're discussing what does and what doesn't currently happen in our schools. So colleagues, I'll probably punch in one more time here and talk a little bit more about the legal process and procedure within which these cases happen. But I do appreciate this conversation, and I think we're really getting to some good issues. So thank you, Mr. President.
Senator Holcroft, you're recognized.
Thank you, Mr. President. I am a member of the Judiciary Committee and voted this out of committee. And, you know, this hearing on LB 441 was held almost a year ago, March 24th, 2023. And I remember it very, very vividly. I mean, I served in the Navy for 28 years, and I've seen a lot of things, but I've never heard any things like those passages that were read. It was pure smut. And it's available in our school libraries. One of the persons who testified gave a little intro before she started reading her passages, and I thought it was a nice setup of history to explain how we got where we are today. In 1962, the Rockefeller Foundation funded a model penal code known as the MPC. The code was developed to define obscenity and compile model laws regarding criminal conduct in regard to sex offenses. These standards were not intended to apply to minor children. The original draft of the code said that law enforcement, universities, or anthropologists may have need to procure obscene materials, and a final draft said it is an affirmative defense to prosecution that dissemination is restricted to institutions or persons having scientific, educational, or governmental justification for possessing obscene material. There is no mention of children in this draft either. But when the MPC was adopted by 43 states, it did not specify that it was intended for adults. That loophole was exploited to extend the exemption to educators and librarians in K-12 schools. Most likely in 1962, no one could imagine that one day we would be battling school porn. The incongruity lies in the fact that obscene materials are by definition harmful to minors and are not protected by the First Amendment. Therefore, the exemption in this statute allowing obscene materials to be procured by minors for educational purposes is in fact illegal. It's time to correct the mistake that was made 60 years ago and remove K-12 minors from the exemption statute. And I'd just like to read my time remaining, a couple emails from constituents. This first one from a grandmother. She writes, Senators, I would like you to support LB 441. It's time to stop all the attempts to sexualize our children by the school system. Eliminating schools exemption is a big step towards this. I'm tired of the education system trying to teach my kids and or grandchildren with the school system, what the school system deems as needed sex education. Let the parents worry about that. I know I didn't need any more information about sex when I was going through schools in the 60s and the 70s. I figured it out. We've been fighting about what books should or should not be in our schools in Plattsmouth over the last few months. There and nationwide, parents attempt to read these books or show images from these books at the school board meetings only to be shut down. It is not acceptable to read this content out loud. Surely my taxpayers' money can be spent in a better way, like teaching those kids who can't read to read. Doesn't that sound like a better use of taxpayer money? Thank you, Mr. President. I'm not asking you to ban the books. I'm asking you to remove them from our schools and let those who want to read those type books to head to the internet and read it there. Schools are supposed to prepare our youth to function in society. They need math, reading, writing, and maybe some preparation on managing their checking accounts, credit card debt, and developing a budget. The Nebraska exemption 28-815 has been on the books since 1977. How much obscenity did you see in school that was provided to you by the school system? How many books could you find that had the F-bomb 62 times, in the book? Until recently, schools didn't have much obscene materials. Now, there is absolute, now.
Senator.
Thank you, Mr. President.
Mr. Clerk, for an announcement.
Thank you, Mr. President. The Revenue Committee will hold an executive session in room 2022 at 5:30.
Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. Would Senator Albright yield to a question?
Senator Albright, will you yield?
Yes.
Thank you, Senator Albright. I'm trying to understand what all this would encompass. So if a teacher is demonstrating how to put a condom on a banana, is that going to be a violation under your legislation?
Truly, I don't believe that that is obscenity.
Okay.
As defined.
Okay. Thank you. That's very helpful and clarifying. You did talk about some other things. I'm concerned about like human growth classes and children learning about reproductive health. Is this going to stymie that education?
First of all, I don't know what they're actually teaching the children about that. So again, I don't know if that would meet this or not. If it's someone from the outside coming in and maybe not bringing the right materials, I think the parents should have the ability to figure out what they're going to be showing those children before they actually.
Well, you mentioned any illustrations of genitals would be in violation.
No.
No?
No. No.
Only some illustrations?
Well, I can go back and read the statute if you'd like, but
Well,
it's obscene to a child. They have that on the floor of our Capitol, and that is not obscenity. That's art.
But I mean, if the teacher is passing out a pamphlet that has depiction of genitals in it.
And for what purpose?
For reproductive health education.
That may or may not, I can't tell you if that's going to be obscene or not, depending on what goes with the pictures.
What would it go with the pictures that would be?
Possibly, talking about what happens, maybe showing them a film that might be inappropriate, maybe, I don't know what the conversation would be. I'd have to look into that to know whether, it's not for me to decide if a parent, comes to the school and felt like it was inappropriate for a minor to see, then that's something that they would have to deal with.
Correct. I mean, that's how it is handled currently. If I feel like something's inappropriate for my children, I address it directly with the school. I'm asking, how would your bill impact that?
Again, if it's inappropriate and deemed harmful to that minor, then they could go to court, and within 2 weeks, the judge would have to rule whether it's obscene or not, whether there's a case there or not.
Okay. Thank you for yielding to my questions. I just, as a parent of 3 school-aged kids who are all in an elementary school, not a junior high, not a high school, an elementary school. A couple of times a year, there's like the Scholastic book sale in the library. And we go after school, and the kids always pick out a bazillion books because they're used to going to the public library. My husband takes the kids to the public library every Monday. It's called Monday Fun Day. And he takes the kids to the library and they check out a bazillion books and do a scavenger hunt. And, but at their school, we go to the library and they pick out books, and then there are bins of books with all of their teachers' names on it, and they are books that their teachers would like to have for their classroom. Thank you. Would like to have for their classroom if a student and parent want to purchase it and donate it to the classroom. So we always, of course, have our kids pick out a book to donate to the classroom. And they're very enriching. And I haven't seen the kind of content that was discussed at the hearing. So it gives me pause, but I am sitting here listening to this conversation. It is quite fascinating, but it does give me pause because it hasn't been my experience at all that there is inappropriate content in my children's school. And nothing that I have heard about or read about in the testimony indicated that this was happening at under 6th grade at an elementary school level, that this was older kids' schools, and the context of what the books were might have been skewed by the presentation. And so I do worry about restricting speech, but also
Senator.
education. Thank you, Mr. President. Thank you, Senator Albright.
Senator John Kavanaugh, you're recognized.
Thank you, Mr. President. Thank you, colleagues. This has been an interesting, enlightening journey, conversation about where folks are at. And I didn't give Senator Albright a heads up, but you mentioned something that in your last conversation with the other Senator Kavanaugh that I was hoping I could ask you a question about, and I'll just give you a telegraph what I'm going to ask you about. You said something about that if there's an allegation, it goes in front of a judge in 2 weeks. I wonder if Senator Albright would yield to a question about that.
Senator Albright, will you yield?
Yes, sir.
Thank you, Senator Albright, and I appreciate the conversation about this bill so far tonight, or this afternoon into evening. Our first evening, this is our first past 5:30, so congratulations. So you said with the other Senator Kavanaugh, if there's an allegation, it would be filed, and I think, could you go back to that? You said within 2 weeks, a judge would make a determination?
Yes, that's what I understand.
What's the basis of that assertion?
I can get back to you on that. That's someone who has helped with this bill and has let me know that within a couple of weeks, you'll have an answer whether it's obscene or not.
I
They want to take it up.
apologize. Somebody's coughing off to the side here. I had a little trouble. So what I was hearing is that within a couple weeks, you'd have a determination about whether the item in question is obscene?
Or if the item would be, listened to in a court of law.
Oh, okay. So whether the case would proceed at all?
Correct.
Okay. Thank you, Senator Albright. So I would be curious to drill down on that a little more. And one of my, as I've said originally, why I think a bracket motion is appropriate here, I maybe would even say return to committee, is that I think there's a lot of questions and a lot of just everyone has a different interpretation of what this bill does. And there's kind of pieces being pulled in from all over the place that are just separate from what actually is happening here. There's case law that helps define what is obscenity. There's some statutory law that helps define what obscenity is. But there is a certain element of, well, famously, the Supreme Court said, you know it when you see it, right? And so there is a subjectivity to it. And certain people think some things are obscene and other people think other things are not obscene. And so I did want to point to State v. Herald, which is the case that defines obscenity for the state of Nebraska again. So it's 256 Nebraska 829 on page 837, the very bottom. Talks about who is the determiner of whether something is obscene. It says the trier of fact must use an average citizen of the Nebraska community, not a particularly susceptible or particularly insensitive one, as a norm for the determination. So what the point of that is saying it's not my perspective on what is appropriate or inappropriate. It's not Senator Albright's perspective. It's not Senator Holdcroft's perspective. It's not the other Senator Kavanaugh's perspective. It's the average perspective of a citizen in that community. And so that is not when we have, folks are getting here and talking about books that they find offensive or things like that were read at this hearing. And I might, again, recenter folks to the definition of obscenity. It is when taken as a whole. And so when you are talking about the one paragraph or 1 minute excerpt of a 1,000-page book or a 500-page book, you don't have the appropriate context to determine whether that item as a whole meets a standard. You don't have a context to determine what the value of that book is or what value that particular excerpt brings to the context as a whole. I heard Senator Duncan talking about the book Mauser.
1 minute.
Oh, thank you, Mr. President. Or I think it's Mouse, which I haven't read, but it's on my list. It's a graphic novel. But there are a lot of books out there that make me personally uncomfortable, and I still read them, and they kind of have me question my perspective about other things. And so some of those, the context of the book as a whole has great value, but there are parts of it that maybe make you squirm a little bit. And that is what the definition is meant to encompass, is that there are parts on their own that maybe push the envelope, but that's not what the definition is held to, and that's not what we're talking about. So I'll push my light because I'm going to run out here, but I think we need to really focus on what this bill does, what the language specifically in the bill and the current statutes as they interplay with each other do. So I'll push my light and keep talking about that. Thank you, Mr. President.
Senator Lippincott, you are recognized to speak.
Thank you, sir. I'd like to read a little quote here from the Congressional Research Service from an article dated January of 2019. It says the free speech clause of the First Amendment prohibits the government from, quote, abridging the freedom of speech, close quote, but does not define what freedom entails. The Supreme Court has long interpreted the clause to protect against government regulation of certain core areas of protected speech, including some forms of expressive conduct, while giving the government greater leeway to regulate other types of speech, including a handful of limited categories that the court has deemed largely unprotected, quote unquote. Unprotected speech in general, content-based restrictions on speech, laws that apply to particular speech because of the topic discussed or the idea or message expressed are presumably unconstitutional and subject to strict scrutiny. However, The Supreme Court has recognized limited categories of speech that the government may regulate because of their content, as long as it does so even-handedly. And as Senator Kavanaugh mentioned just a few moments ago, there is some subjectivity in it all. The court generally identifies these categories as obscenity, defamation, fraud, incitement, fighting words, true threats, speech integral to criminal conduct, and child pornography. The contours of these categories have changed over time, and many have been significantly narrowed by the court. In addition to the Roberts Court, has been disinclined to expand upon the list, declining to recognize, for example, violent entertainment or depictions of animal cruelty as new categories of unprotected speech. Obscenity. In order for material to be obscene and thus unprotected under the First Amendment, it must, on the whole, appeal to the prudent interest in sex as judged by contemporary community standards, depict or describe sexual conduct as specifically defined by state law in a patently offensive way, and lack serious literary, artistic, political, or scientific value. It's interesting to note that statistically, 1 out of 5 mobile searches today is for pornography. It's rampant in our society. As a matter of fact, 56% of divorces include a partner's obsessive interest in pornography. We all remember Ted Bundy from a number of years ago down in Florida that was put to death because of multiple murders that he produced, that he committed. And he was interviewed before his death by Dr. James Dobson of Focus on the Family, and Dobson asked him, how'd you get started down this path? And he said when he was a child, a young person, he started becoming obsessed with pornography. It's rampant. It's all around us. And the idea that we here as a legislative body do not want to participate in establishing some guardrails is really beyond me. We need to protect our kids. We really do. And I understand what John Kavanaugh said a few moments ago. These guardrails do tend to be subjective. Who declares what is right, what is wrong, what's obscene, what is not? I understand that. But the bottom line is, and our objective needs to be, to protect our kids. We don't need any more Ted Bundys. And we do need to protect young women. Thank you, sir.
Senator DeBoer, you are recognized to speak.
Thank you, Mr. President. I'm a little confused about what we're doing totally here. And the reason is because I think we're having two separate conversations. The bill talks about obscenity, which is a term of art under the law. But what was in the hearing and what I think a lot of folks are talking about here that they would like to not have children be exposed to is what I might call, and I have a series of words here, bawdy, ribald, spicy, suggestive, vulgar, salacious, or risque. Those things are not the same as obscene under the law. This bill deals with obscene under the law. What I think I hear folks saying is that they would also like to regulate those things which are bawdy, ribald, spicy, suggestive, vulgar, salacious, or risque. So my sort of way of envisioning is that there are things which are obscene under the law. They don't have literary merit, they don't have anything, etc. There are these things which we might call spicy. And then there are things which are not spicy. And we're not really arguing about the spicy. but some of us seem to be talking about, and the bill seems to be talking about, obscene under the law. But then what I hear, I think the intent of some folks supporting this bill is that what they would really like is they would like more things to be moved from this category of spicy over into the category of obscene. I think that's what folks want. They want more of the things that are currently in the spicy category to be reclassified as obscene. But I don't think this bill does that, because there is still the requirement under law that you prove that it is obscene under the law. And then that's where you get other folks talking about the slippery slope, because right now I am wearing a skirt cut at the knee. At one point, that would have been certainly spicy to wear that. And now no one would think, actually, it's somewhat modest to wear one cut at the knee. So I guess what I'm saying is, if what the intent is to declare more spicy things obscene, I don't think this bill does that. And so I'm a little confused why we're changing these things, which I don't think will have the effect of making more things which are spicy obscene under the law. And so I have a little disconnect with what's going on out here. And I am a little concerned if what we are trying to do is to sort of take some of these things which are in the spicy category and put them over in the obscene category. At what point does that take some of the things that are not spicy and put them sort of in that middle category? And are we just sort of shifting things? And what are the consequences of that? And should we, as legislators, be trying to do that? And can we even be successful at doing that? If what folks are saying is that they would rather not have kids exposed to spicy things,
1 minute.
then I don't know why we're doing this bill. That's the question that I have. I do have some technical questions as well. I'll just put one out there so that folks understand that it's a question I have and it's something maybe we can answer at some point, which is, there's an exception under current law that says news media are allowed the affirmative defenses. So if I'm a news media and a journalist, and I put some obscene thing out there, and then a teacher picks up the news media, or actually a librarian or whatever, and shows what's in the news publication, does the librarian have different affirmative defenses than the person who wrote the piece of information and both got into the hands of kids? Right? So is the teacher being held more responsible?
Time, Senator.
Thank you, Mr. President.
Senator Albright, you are recognized to speak.
Thank you, Mr. Speaker. I really do appreciate all this discussion on the floor, because I think it's going to, hopefully within 8 hours, end up helping us understand why we are doing this. And I know if John Kavanaugh, Senator Kavanaugh, I do have a few answers for you here. If you were to go to, okay, let me see here. If you would go to a state statute under 28-816 and 28-820, the court is required to rule within 2 weeks on whether it is obscenity. Okay? And I believe Senator Duncan had LB 441 does not ban artistic, bothersome, racy, or uncomfortable books that have literary value. That's not obscene by definition. And Michaela Kavanaugh, whether it's obscenity, we have to obviously identify state statutes 28-808 that's been in law since 1997. And regarding 28, 816, and 820, it's a declaratory judgment. So you as attorneys can decipher this part of some of the questions that are on the floor. And again, the 28, 815, the prosecution and defense is what comes into play here. And I do know that I so appreciate the Judiciary Committee sitting through. I think we had, and I think this is important for people to understand, that's why we're talking about this today, but we had letters from 265 proponents, and there were 36 people that testified, and we had 343 opponents, and 17 people testified. And I'm sure that you can all go to the committee statement. I want to make sure that some of the questions that were asked that I can get to. I believe Senator Blood wanted to know if we had any attorneys. I don't know if any of those were in opposition because they could have come as themselves and not, with a firm or whatever. But I know the only company type or businesses would be a higher power church came as an opponent. The Nebraska State Education Association, Stand for Schools, opposed. The American Civil Liberties Union of Nebraska opposed. Women's Fund of Omaha opposed. Nebraska Library Association opposed. Nebraska School Library Association, there's two different people that came up and opposed. Academic Freedom Coalition of Nebraska and the Nebraska Library Commission. So again, I'm sure, there's going to be concerns if something is in our library, but if we have to question whether it should be in there or not, then I'd say that it's probably too obscene and it's harmful to minors. But it's not a full swoop. Just like you say, some of you might say it's okay to read those books, but they should go on the library day with Kayla Kavanaugh's family and go out and find the books that they think would be much more interesting than what is in their library at school. I strongly believe there are enough books out there that we certainly do not need to be putting our children in harm's way by reading books that truly, I don't see the education in them. But again, it's for every parent to parent their own child as they wish.
1 minute.
But I do not want to see, nor do I believe that anyone should not be held to the highest standards, whether it's the teachers or the librarians or the school boards or the principals or the superintendents. Anyone that has contact with our children during a school day should not be allowing anything of the sort to happen. And you know what? I would never want to go through what the Judiciary Committee had to sit and listen to. I know there are several people that did not stay for all of the hearing, and I can understand why. It was brutal to sit and listen to. I mean, I have never in my life, 65 years old, been exposed to anything quite like it. And if we can't listen to it or even read it out loud on this floor, it shouldn't be in our schools. So again,
Senator.
Thank you.
Senator Hunt, you are recognized to speak.
Thank you, Mr. President. Good afternoon, colleagues. Good afternoon, Nebraskans. I think the problem opponents have with this bill, and Senator Conrad said this very well, it's not that we don't all want to protect kids. Everybody in this body obviously shares the goal of protecting kids. The problem is that everything is obscene to you people. Everything scandalizes you. You think that there's a spectrum between, what you're comfortable with, what you're okay with your kids consuming, this and that. You would be scandalized by two men holding hands. Like the things that you can't tolerate, that you're uncomfortable with, they are not normal. It's not normal, the things that are obscene to some of you. And, actually, in my view, there's nothing that my child could find in a library, whether it's a public school library or the public library in Omaha or whatever, that I would be upset to have in my home. Honestly, we should be saying, thank God if these kids are in the library at all. If someone told me when I was 14, 15 years old that if I read Lady Chatterley's Lover, there would be a sex scene, I would have read that so fast. And every other book too. Ulysses, all of these books that have been on banned book lists. And I think for any generation, any of you when you were 14 or 15, you would say the same thing. It's just part of growing up. It's curiosity, it's literature, it's art. And we can't ban or legislate away all of these things from kids consuming or seeing. What do you think kids are talking about on the bus? What do you think they're talking about in the lunchroom or at recess or in the hallways? I've got a teenager. On Saturday, we had a sleepover with 5 kids. And, I don't know if they know this, but I could hear what they were talking about. Was it all appropriate? No. Was it age appropriate? Yes, it was age appropriate. And it was the same stuff, if not better, than things that I was talking with my friends about at that age. And I'm sure the same goes for all of you in this room. When we just have such different thresholds for what obscenity is to all of us personally that we cannot pass legislation like this. This can't live in our statute in Nebraska. And what this is really about, I believe, for the introducer is just opposition to sex education as a whole. It's about the introducer and some of the supporters, people like Kirk Penner, whatever his name is, being so scandalized by anything sexual at all, which I think betrays a psychological problem, honestly, that we're so uncomfortable with these kinds of things that are very, very normal for all humans. But that's actually what got me involved in politics in the first place. In 2015, which now feels like a longer time ago than it feels like in my mind, I was involved with Omaha Public Schools and Planned Parenthood and the Women's Fund in the effort to update the comprehensive sex education curriculum in Omaha Public Schools. At that time, our sex education, our human growth and development curriculum hadn't been updated since 1971. So there were some kids that were getting the same sex ed that their grandparents had gotten. And since then, we've had the internet. We've had an increasingly out and increasingly depressed and suicidal LGBTQ population that's looking for representation of themselves in the media and schools and their education. We've had the AIDS epidemic. We've had, basically the world, thank you, Mr. President, the world in 2015 was not the same world in 1971. And so, long story short, we did it. We did update the sex education curriculum, and it was very hard, sometimes even violent, some of these hearings. And it really mirrored what you saw at the state level when the State Board of Education was trying to do the same thing. At its heart, this is not going to protect kids. It's going to have a chilling effect on educators. It's the same thing, it rhymes. It's not exactly the same thing, but it's like what happened when we had an abortion ban. All of a sudden, doctors are afraid to provide life-saving care to their patients until these patients are, in sepsis and dying, and then they can give them the health care they need. But it prevents, when we pass these bills that have these chilling effects, it prevents professionals from doing their jobs. We can't pass something that prevents teachers and librarians from serving kids, from recommending books that are age appropriate.
Time, Senator.
Thank you, Mr. President.
Senator Wayne, you are recognized to speak.
Thank you, Mr. President. For those who have not read the transcript, that was one of the most interesting hearings, and I'll be short and yield the rest of my time to Senator Albright. But, it was one of the hearings where if you read it, it's embarrassing that some of these books are actually in some of these classes and some of these libraries. But nevertheless, if you wanted to take them out because you thought they were obscene, you told the principal and they still didn't do anything, or they neglectfully forgot to do anything, under current statute, you can't sue the school district anyway, because that bill is the one that we've been trying to fix for that, 341, which we'll get out. But anyway, I just want people, if you check out that transcript, it was, it was, I can't even describe the words. It was unbelievable what people could be reading in some of these classrooms. And with that, I will yield the rest of my time to Senator Albright.
Senator Albright, 3 minutes 50.
3 minutes and 50. I guess I can just say K through 12 is not protected in the state of Nebraska from obscenity. I think the floor is clearing out. We'll have them coming in and coming out, but I think you have to just keep repeating that no one is above the law when it comes to minors, when it comes to the fact that they can show them whatever they feel is appropriate in their eyes. And yes, Senator Hunt, you and I will absolutely differ on different ways that we view things, but that's okay. You know, you're certainly welcome to take your children to a local library and they can pick out whatever they want, but not in our schools. There should not be a reason to pick out something that is obscene to a child and any of us believe it's okay. That is our job, to protect those children every day and know that when we release them to the school system that they're going to be protected. And we know today it's not like it was when we were in school. Certainly not like it was when my children were in school. And it's changing every single day. And either we get a hold of it and we make these laws so that the State Board of Education won't bring those decisions to our schools that they can do whatever they would prefer to do with our children without our knowledge, without knowing what's going on in the classroom. There's reasons that parents have asked for opt-outs. Not everybody's there. Not everybody's on the same page. But obscenity is harmful to minors. It's already in law. All we have to do is ask the question, is this obscene or isn't it? It will give pause to all school systems throughout the state, whether we need to be doing this or not. I can't imagine anybody leaving this floor not wanting to protect these children. And we're not talking about just any old book. You can put a label on them, whatever you want, but come take a look at this transcript. And you tell me if your child brought that home, I don't care what age they are, and read that out loud to you, you'd be okay. You're not, I just can't believe K through 12 has to be protected, and it's our job. It's the job of every legislator on this floor to do the right thing. And I'm happy to talk about it, happy to talk about it for 8 hours. I think that we need to take heed to these people didn't just show up because they didn't have anything else to do on that day. They showed up because they want to protect their grandchildren, their nieces, their nephews, their children, their neighbors. This isn't right. I mean, we have to understand that the children today are being put in front of things that they just cannot figure out. And quite frankly, I know that I had lots of visits with Senator Wayne about what happens in some of these schools and some of the kids that he's representing. Those children should not be in court over doing some of the things that he has to defend. But you know what? They're there because we allow them to read things like this. They think it's normal. They think it's okay.
Time, Senator.
Thank you.
Mr. Clerk, for announcements.
Mr. President, the Retirement Committee will hold an executive session at 6:45 in room 2102. New A bills, LB 130A offered by Senator Dorn. It's a bill for enacted relating to appropriations to appropriate funds to carry out the provisions of Legislative Bill 130. Senator Boston, LB 867A. It's a bill for enacted relating to appropriations to appropriate funds to carry out the provisions of Legislative Bill 867, 108th Legislature, second session 24, and declare an emergency. Amendment to be printed, Senator McKinney to LB 840, Senator Blood to 876. That's all I have at this time.
Thank you, Mr. Clerk. Colleagues, the legislature will now stand at ease for 30 minutes, and we will regather approximately 6:30.